Good morning, good morning, good morning, good morning, good morning, amazing law nerd. Today is Wednesday. It's February 18th, 2026. We have lots to talk about today. We have some law nerd things to talk about, and we have some court things to talk about. We have to check back in before we start trial in Corey Richins. We have to check back in with the civil case going on with Karen Reed, because there have been 3 discovery hearings. We are going to go through the one from yesterday at the end. We're going to go in time. So if you've watched any of these 3 hearings, thank you for no spoilers. But we are going to go in time order of the discovery stuff that's going on this month. This is the day in and day out boring law that in this case is of course not boring, because what would be normal? Right? So this is the stuff that normally goes on behind the scenes. In criminal cases, we don't see nearly as much discovery conversation. I mean, I guess in Massachusetts, we kind of do. In Massachusetts. We kind of do. But the ins and outs of civil litigation that we don't often see, we are going to take a peek because we learned some new things. Thank you, everyone who knows what Proctor problems are popping off. The Proctor problems are popping off for no spoilers, because I was trying to prep this and pulling up motions that were filed yesterday in some of the criminal cases we've been tracking, like the Miles King case, because those cases are still ongoing where they're fighting over Proctor's phone. And then remember, it was in those cases where we learned that Proctor had rehomed his phone and gotten a new phone and told everyone, like, oh, you're not going to get much from the phone. And then they got the entire iCloud and like tens of thousands of things and like emails and text all the way back to like whenever. Remember that? Right. So those are still going on. But also there's a whole civil case going on. And where the two meet in the middle today is going to be wild. And then Karen Reed is having some tech issues as well, and we're going to talk about that. Karen Reed is having some of her own tech issues because she is having her own tech issues. So we're going to talk about all of that. So we've got 3 hearings we're going to go through. Some of them are a little bit shorter. They are all the civil hearings with all the lawyers for everything. We have some motions we're going to go through. We have a whole lot of litigation over the hearing that happened yesterday. So we're going to go through the earlier discovery hearings, the documents about yesterday, and then the hearing from yesterday. Sound good? Sound good, everybody? All right. Tell me where you're coming in from, what you're drinking. I've got a cappuccino. I've also got the remnants of breakfast because I was doing a few other things this morning. We're going to talk about that in a minute. And I left it in the oven just a titch too long, but it's okay. It's going to be delish either way. And what's better than discovery hearings and chocolate croissants? I mean, that's the way I'd prefer to go to court, wouldn't you? Like, we're just there with snacks at this point. We're there with snacks. All right, law nerds, we have a lot to talk about. Let's roll the intro. Let's get ready to rumble. I think that's probably like trademarked, copywritten. Let's get ready to court. How about that? Let's roll the intro. We have some other stuff to talk about, but yeah, let's go.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
All right, law nerds, how many of you have the Law Nerd app in the chat? You don't have to put it in the chat. I know how many of you do. Because if you have the Law Nerd app, you were greeted this morning with some, hey, Law Nerd, hey, we have some things for you. And we do. If you do not have the app, you might have missed that early announcement that the Law Nerd shop is open. And also, we have some new merch, but I can't explain. Do you want a little behind? We're just friends here. Look, this is the benefit of being early to stream. We're all just friends here. This is the behind the scenes tea. We also have some of our closing time items, which are things that are not coming back, that are on limited supply because we work with a distribution company that works with, name a musical artist. And the law nerds are that kind of audience, and it works well for us. But when we are working with larger warehouse facilities, sometimes we hold things just to make sure if something gets broken, we can send you a new one. But we found some extra things. And so when we went through and did our end of the year, like, where's this, where's that, we found some extra stuff. So that is in closing time, but it is literally what's there is there. When it's gone, it's gone. And we have our new Law Nerd Love items, including this hoodie. I love the drop shoulder hoodies. The drop shoulder hoodies, I know not everybody loves a hoodie. Don't worry, we have a zip up. The drop shoulder hoodies are oversized, and I size down almost 2 sizes from what I would order in other things. So they are oversized. Look at the sizing on those. They are a lighter weight hoodie. I wear them year round. If you live somewhere where it is often warm out and then air conditioning, this is the perfect vibe for that. Also, the fact that it's like almost Ryan Hall y'all weather outside is really just messing with my lighting. It's just messing with my lighting. But the Law Nerd Love logo, I love. Look, I love. Also, we have a zip up. We know how much y'all love the zip ups. The zip ups are a thicker, warmer, heavier zip up hoodie, like the ones from the EDB Air launch. I'm knocking things over. I had to hide this because Fred keeps trying to sleep on it. And it has our Law Nerd logo down the arm. It's on the arm. Look at it. It's all down the arm. It's so cute. Emily, you can't do this on screen. No, it's easier in person. Look at how cute it is. It's so cute. And we got our little uni. We got our little uni on it. I love it so much. So that is our black zip up hoodie. We are working on other colors of hoodies for other launches, but the unicorn pops so well. It just pops so well. And then we have some shirts. Hold on. I got to hide this from Fred. I love these. Look at how cute. And we have our unicorn on the back. And they were like, unicorn on the back. I'm like, bigger. They're like, unicorn on the back. I'm like, bigger. And then we're here because I love it. Because I love it. We have some other things in closing time that you may love. We brought back the straight facts hat. That's not the one that says no fuckery on the back. It is the straight facts hat that just facts. The spicy facts hat is the one that says not fuckery on the back. We are talking about bringing those back. We do have international shipping. Not everything ships internationally, and not every country ships internationally. We are working on that as best we can. Let's see. Some of you are saying the cup is already sold out. There's a lot of y'all in the app. And so when the app notifications go out in the morning, that can happen. It's hard to tell because the last tumblers did not sell out this fast. And then we ordered more from what we ordered last time. And then these sold out super, super quick. So, yes, these sold out very, very fast. And that, again, the app notifications go out before we go live. So we really need the Facts Not Fuckery cap. They are on our list. Those are something that we will be bringing back. Butterscoop said, what do I do if my tumbler straw broke? Email help@, and we can help you on that. We can help you on that. Oh, that's fun. I was going to show you my screen, and then my screen was like, hey girl, hey, what you're not going to do is that. That's so delightful and fun. I got everything else done today. And yet, I don't know why that one wants to be spicy. So let's take a look real quick before we go to court, because we are going to go to court. But I'm really excited. Team Baker has worked really hard to bring you guys another launch. I love to hear it. Smart. I have missed the middle. Smart Tech Addict. There we go. My brain got it. Shipping is cheap to UK. We have worked very hard to make sure that we do our best with ship. There was a lot of behind the scenes work. Maybe on a members only, we'll talk about how much. There's a lot of behind the scenes work to make sure that shipping to everywhere we want to ship to is reasonable. It gets harder and harder the further out we go from shipping from the US. but we do our best. So Lawnard Shop is live. Let's just do this. Lawnard Shop is live for y'all. Straight Facts hat is in there. I know that I should probably refresh because the tumbler is sold out. And then we have lots of fun last chance things. I think the sticker pack is almost sold out, and the notebooks. So if there are things that you guys are interested in, we also have some stuff on sale in our last chance area. And then some of the things you loved from previous launches are still available if you want to go grab those. You guys see me use the koozie set all the time. I absolutely love them. If you didn't get some of the pins from the past launches, those are there. So have fun, Law Nerds, while we talk about court. Don't worry. We are going to have more launches, but we are not going to have another launch for a minute. We do not drop things back to back to back. We are very, very mindful of y'all. So, all right. Let's get ready for court. All right. Let's get ready for court. It is time for Karen Reed stuff. Should we fly to Massachusetts? Let's do that. There is so much going on in the civil wrongful death case. And today we are talking about the civil wrongful death case that is happening between the O'Keefes, Karen Reed, the Waterfall, C.F. McCarthy's et al. It is not like Karen Reed sues the world. Karen Reed sues the world is a different federal lawsuit, and we will get into that one another day. Today we are doing the O'Keefe's versus lawsuit. Wait, who just said in the chat, make sure you pre-shovel your parking spot? The Massachusetts parking spot saving is everywhere. It's everywhere. That's amazing. Yes, pre-shovel your parking spot so it's yours while we talk about court. Outside the courthouse, go pre-shovel your parking spot outside the courthouse. All right. So we are talking about the O'Keefe case. Fred has blessed my microphone with fuzz, and it's wild. Okay. So with that lawsuit, remember, Karen Reed wanted to sue everyone inside of that civil wrongful death suit and then filed a separate suit. So there is separate Karen Reed sues everybody, like Karen Reed versus the world, O'Keefe's versus the bars, and Karen Reed. That's where we're at. We are sticking with the O'Keefe's versus lawsuits today. There are discovery issues going on where, shockingly, as people are trying to get discovery, they are running into pretty stringent bumpers. Shock me when they're like, hey, we've subpoenaed people, and they're not responding. So we're going to look at some of that and how the judge is handling it. And then we get into Proctor problems. And then we get into Karen Reed responding to an email that was BCCed. And opposing counsel being like, nah, we're not giving it back. I have a lot of thoughts on that. Look, I did not practice civil nearly as much as I practiced criminal. For those of you that are newer to watching me talk about all of the legal stuff, I worked as a research attorney for 2 civil judges. That amount of time was enough for me to go, never again. Never again. The amount of emails back and forth that are like, you did this, you suck. Your client did this, you suck. Govern yourself accordingly. The amount of blustery, vitriolic, just extreporous nonsense that went on in civil drove me crazy. And in criminal, though we do see it sometimes, it's different. In criminal, what you generally see is people who are going to go to court. But in criminal, it's like, hey, whatever I've got, I have to give to you. Here you go. And then we'll argue about whether it comes in or not. And we can make accommodations for each other. And it is a much smaller bar. And you end up working with the same people over and over and over again. And if you burn people, it will burn you. And so people tend to work a little better together. Plus the rules in criminal are different. And everyone in criminal should take seriously, hey, we are dealing with somebody's life and liberty. And hey, We are dealing with a victim who has had like the worst thing in the world happen to them. Can we all just turn over discovery and just move forward like adults and follow the rules? Civil pushes the boundaries of, rule versus guidelines. And it is nonstop. And it is a fuck ton of emails. And it is just, no. I would be a terrible civil lawyer. I was a water polo player. I would get 3 emails in and be like, come to my office. Come say it to my face. Come say it to my face. No, I know myself better than that. It would make me crazy. So civil is a mess. Disney Lover for Life said, my mom was a civil lawyer and she is working nonstop, even on vacations. Yes, her brain is also working when she tries to sleep. Civil is where you hear the horror stories about like second-year associates getting a text message at 3 a.m. and being like, why haven't you gotten this back to me? Like, what are you doing sleeping? Not for me. So we're going to civil land today. So remember, we're in civil land. It's in a different land. It is not my vibe. Kelly said, so you would be Ron. No, I'm self-aware enough to opt out. I have opted out of the things that don't work to me. Look, I know where my strengths are. I know where my weaknesses are. I have opted out. I do tend to do better when it is not personal, but civil is just so feisty. And I would just be like, bro, what are you doing? Like, stop it. Civil makes me crazy. So I opted well. Look, I worked with the judges and I would go sit in with my judge and be like, how do you not feel like you're talking to 4-year-olds when these lawyers come in and you're like, okay, everyone, have we given our line buddy discovery yet? No. Okay. 3 months ago when we were here, we were getting that done. Why isn't it done yet? All right, everybody, you're not going to have a trial date for like 3 years if we don't get this done. All right. Okay, can we just exchange discovery? Good. Okay, you need to answer your interrogatories. Yeah. Can we get those done? When are we going to get those done? Good job, everybody. No. Blech. No. Nope. So civil would make me crazy. We're going to jump into it today because it's going to be all of the mess. So we're going to just start with the first civil hearing and we are going to get to more of them. Who said civil is hurting cats? Yes. And the more parties involved, the more lawyers involved, the messier it gets. I couldn't. 13 Flag says, was that why Judge A sometimes talked the way that she did? 100%. 100%. And Judge A had a great temperament for it. I have a your adults act like it temperament. Like if I have to give you more reminders than I need to give my very neurospicy children, I will lose my mind. Criminal worked better for me. Yeah, I know yourself before you pick what to do in the world. That's my best advice. Know yourself. Just know yourself. There's a right spot for all of us. But civil has the big bucks. Criminal is not where the big bucks lie, except for a very small percentage in the criminal defense world. That's not where the big dollars lie. It wasn't ever my focus. I wanted to do something I enjoyed every day. And now I get to do this. Right? Best ever. Okay, for those of you just coming in, if you are interested in the Lawnard shop, go check it out because the Lawnards are making sure that they are purchasing exactly what they want very swiftly. So there are things that are going to be sold out before the end of stream. So go double check what you want. That is my reminder. We are going to go to the hearing from February 3rd first. This is a discovery hearing to figure out where we're at with discovery. Then we're going to do a follow-up hearing from February 17th. It's a shorter hearing. Then we're going to get to the hearing from yesterday. Sound good? All right. Also, favorite thing about criminal is that criminal, especially in Los Angeles, is so busy that most of your motions are spoken. And so you get to just stand on your feet and talk all the time. All of you are shocked. show me your shocked
Yes,
face
Your Honor.
that Emily preferred to just, can we just do oral motions? Shocking. We're all shocked. All right. We are going to, let me see. Let me put up our hearing date. What did I say? February 3rd? This one's from February 3rd. Are we ready to go to court? I mean, it doesn't feel like court because it's on Zoom, but we're going to court. So even though we're on Zoom, we're going to court. I know all of you are showing me your shocked face. Leonard, you're the best. I know. Emily, rather just talk. You don't say. You don't say. Let's go to court. The judge is hiding down here. The judge is also like stuck in like a law and crime logo cage. We'll talk about law and crime buying Court TV another day, but the judge is like stuck. Oh no, that's not what I wanted. I was not trying to move that. But the judge is stuck down there in like a logo cage. See? All right, well, that's what I moved by accident. It'll be fine. It'll be fine. We'll just leave it like that. There we go. But we'll talk about that another day because I have thoughts. All right. Let's make sure we have our captions on.
I can confirm that we
I
have
love
some
these.
very technical folks on our end that have been trying to access the document.
It is hard for me to read everybody's names. Here's the problem. This comes in the minute. This comes in just a minute. All of you are just like, wait, that's new news to you. Okay, hold on. I didn't realize I was dropping new news. Sorry, law nerds. I casually dropped new news, and that's not what I meant to do at all. Okay, let's back up real quick because all of you are like, what the fuck did you just say? 30 seconds. We'll detour for 30 seconds. I see I have rattled. Apologies. Okay, we'll do a quick news story. My bad. So sorry. That's on me. Emily, you can't just say shit like that and then move on. Okay, fair. That's my bad. I realize that I am way too like inside baseball on this stuff because my phone and DMs blew up the day that this happened because people were like, did you see this? Let's just talk about it real quick. All right. So last week, I guess we're doing a quick bit. Oh, look, we haven't done this in a minute. Hold on. I guess we're doing a quick bit with breaking, not breaking news. Law and Crime purchased Court TV. I didn't mean to shock everybody. Law and Crime purchased Court TV. That acquisition was announced this week. There are still some unknown factors of this, but we can go to the news article. This is from, where is this from? This is from Deadline. My phone blew up this day. This happened this week. I don't know what are days? This happened, I think, maybe end of last week, beginning of this week. Deadline, why is there not a day that this fucking hell? All right, whatever. Court TV has been purchased by Law and Crime. EW Scripps, which was the owner of Court TV, relaunched Court TV in 2019, which I did not remember that it was relaunched. Relaunched Court TV in 2019, sold the network to the Dan Abrams run studio Law and Crime, which is owned by Jelly Smack. Financial terms for the deal were not disclosed. Since 2023, Law and Crime has been owned by Jelly Smack, a holding company for creator-led media businesses. I'm talking about that, don't I? Mm-hmm. Abrams has long worked as a TV legal analyst, currently on ABC. He's also known for series like On Patrol Live, On Reels, and Live PD, and an A&E show. I will just tell you, I've been asked to do multiple shows. We'll save that for members only. Every time I say no. Every time I say no, you know why? Because I run the Emily show and I get to do what I want. And they're like, we want to do this. I'm like, that sounds hyper sensationalistic. I don't want to do that. Are you going to let me have input on the titling of things? No? Okay. The Emily show. So Jelly Smack does had done stuff in the creator realm, then bought Law and Crime, and is now acquiring Court TV kind of under Law and Crime. So they talk about Dan Abrams. They talk about the YouTube channels. The official announcement of the deal, Abrams said he intends to maintain Court TV as its own brand, distinct from Law and Crime. Court TV will become the hub for all trial content and coverage and continue its important tradition of giving viewers an inside look at some of the most fascinating and important trials. Court TV was a trailblazer in gavel-to-gavel coverage of legal proceedings, including brand-defining ones like the murder trials of O.J. Simpson and the Menendez brothers. How did Casey Anthony not get included in that? But okay. Under Scripps, the network covered prominent cases like Johnny Depp and Amber Heard, the murder trial of Alex Murdaugh, and Minneapolis police officer Derek Chauvin, who was convicted of killing George Floyd. In its prior incarceration. In its prior, we're going with incarceration. We're just going to leave it. Court TV rode the moment of cable television through the 1990s and 2000s and took advantage of permissive rules in states like California allowing cameras in courtrooms. Off-screen, the network has served as a training ground for a number of executives working under CEO Henry Schliff, who rose to prominent posts across the industry. Abrams worked as a reporter for Court TV in the 90s. I mean, so did Savannah Guthrie and many others. Scripps operates a portfolio of multicast networks, acquired the IP from the network Turner Broadcasting in 2018. That's the IP for Court TV. And returned it to air May 19 with a multicast strategy on YouTube, like Roku, TV, etc. Selling the network is consistent with the broader strategy of Scripps. CEO Abrams said in a statement, "We identify where consumer behavior is headed. Yeah, YouTube. Build and grow businesses and meet those evolving interests to make strategic decisions about how to unlock their greatest value." Because even when people are watching on TV, they're watching on YouTube. So, Court TV has been acquired by Law and Crime. They say that Court TV will stay its own distinct brand. I think what we will see is that the Law and Crime Trials YouTube channel will kind of become the Court TV channel. I don't know if the Court TV shows and podcasts will stay the way they are or will shift. But what Dan Abrams has said in other statements is that the focus will be that Court TV is the place for live trials. Remember, I didn't realize we were going to go so deep into baseball, but remember, Law and Crime sued Court TV not that long ago over Court TV's logo saying, we're the only place to watch live trials. I mean, none of them can say they're the number one place to watch live trials because by live concurrent viewer, we are the number one place to watch live trials. So there was a lawsuit over that, but I think it will consolidate the cameras in the courtroom, which if courts keep rolling out like Idaho, they might not even have that because legacy media was big mad over Idaho coverage because they didn't have special access to the camera feeds because Idaho said, we'll do it ourselves. It's going out on our own channel and that's it. And I think courts are going to go that way. I think we will see more courts saying, we'll control our own cameras and it'll be more like C-SPAN. We're not going to do a jump cut to the pores of the defendant's nose. We're going to have one camera that covers like the judge and the witness stand and one camera that covers the counsel tables. And that's it. And now that courts have shifted post-COVID to allowing for Zoom conferences like we're going to see here today, courts are set up for it. And I think we will see courts moving to cameras in the courtroom, which means the ownership of, hey, we're the pool camera starts to shift. But Court TV and Law and Crime often apply to be pool camera for the same cases, and only one of them gets it, and then they all collaborate together to distribute those feeds. So Court TV, I think, will still have the pool cameras in the courtroom for most cases. Law and Crime won't even compete with them on that because now they're all under the same parent company. Court TV, I think, will have the live, uninterrupted gavel-to-gavel on their channel, and then I wonder what will happen with some of their shows and if we will see all of their shows staying or not staying. So it will be interesting to see how this rolls out. But Court TV did just sign under now Law and Crime Jelly Smack a deal with Scripps to still allow CourtTV over the TV broadcast for a number of years going forward. So I imagine we won't see huge changes. We will see shorter changes, but what it won't change is that when courts grant a network like CourtTV or whoever pool camera access, they do not have exclusive copyright on it. They still have to distribute it to everyone. So I don't think we will see an issue with court access. I think we will see just a shift in the way the programming works, because Law and Crimes channels have definitely leaned more into, grabbing your attention with headlines. And if they've pushed all their live trial coverage onto a separate channel over the last year or two. So we will see what happens. But yes, let's go to court. Either way, let's go to court. And this comes to us from the court's Zoom. And yes, Baker Media does apply to be media in a lot of these courts, because then we have access to it too. So we'll build it ourselves. We'll build it ourselves. And we're not for sale. We just stay in our own little corner over here and build it ourselves. We don't like having bosses. Truth is, EDB does have a boss, because otherwise EDB would never get anything done. I just got to pick my boss. That's the real tea. All right, let's get back to civil hearings. If you hear noise in the background, there is vacuuming happening. So there is vacuuming. There's vacuuming. All right. If you build it, they will come. We absolutely build it. And I think we went with if the law nerds ask for it, we will build it, then we'll break it, then we'll build it, then we'll break it, then eventually it will not break anymore. And that's what we do. All right. Becky said boss or a wrangler. A little bit of both. A little bit of both. Let's go to court. Let's go to court. Wait, no, damn it. That was supposed to be the gavel. That was supposed to be the gavel. That was supposed to be the gavel. Shimmy said, I thought CourtTV was like C-SPAN, didn't realize they were a commercial company. Yes, they are. And I wonder if we will see shifts there.
For the same purpose of moving this case forward. And it's been difficult.
Oh,
and so now we're put in the position of trying to take what has been produced.
One of the things I am so geeked about with our new streaming software that we built is that we have so much better control of the sound. It's so good. It's so good. All of you are saying, Emily, that was a full Freudian wah-wah because civil court. Okay, facts. Okay, facts. So we've got all the attorneys in the squares, the judges down here at the bottom covered up by the judges in logo jail, and the attorneys are discussing civil discovery.
And get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved just as Mr.
There is so much discovery. They are getting an e-discovery vendor involved. And part of the problem is the attorneys have been trying to access discovery and have been having trouble accessing files. Right.
Diller is to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty
So all of the discovery just got dumped into a file and nothing's labeled. And they're like, Your Honor, come on. What?
Trying to weed through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
What depositions, if any, have been noticed by CNC?
The court has just moved on. The court has just moved on. What depositions are we doing? Okay, you're having a difficult time getting discovery. Great. Now what?
See.
We have not noticed depositions for two reasons. One, there will probably be...
This is the lawyer for CF McCarthy speaking.
very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties.
So you're waiting for them to go
We have
first?
talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then,
Diller
of course,
represents
Mr.
Reed.
Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
So this is
Thank
the
you,
attorney
Your Honor.
for the
David
Waterfall
Hassett.
Bar.
Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have...
All right, these are the attorneys for the Waterfall down here in the bottom corner near where our Lawnerd logo is.
A discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list. And the hope was first to review the documents before starting that process.
So they want to review documents before starting to do depositions. We're going to talk more about depositions in the next hearing. Can the lawyers cross-reference evidence from the Karen Reed trial? They need to know what's being turned over to them because it's coming from the different teams. And this is something that does happen in civil discovery, where it happens in criminal discovery too. Unfortunately, we've seen it in cases where it's just like a dump of just everything. And these discovery dumps, things can get buried, especially when you're dealing with like large litigation with large companies. But with e-discovery, a lot of law firms just have outside vendors organizing all of this and helping them parse through what it is. So it's a whole thing, especially if the files won't open.
Do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor.
That's to Waterfall.
We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank. There'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files and our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata.
If we start talking about load files this early in a stream, everything is going to come off the rails. Thanks, counsel.
It appears that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents assist
This
with
is
whatever
Attorney
technical
Rosenberg.
issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But
Sorry, I didn't realize the closed captioning
I understand
moved.
there is a lot of paper here, and there is a need for e-discovery vendors
Yeah,
because
there's a lot of paper.
Primarily, the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear there. To the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that
A lot of you indicated that it was easier for you to read the closed caption down here. I'll move it back down. This one is closest in real time. So we had the majority of chat say that it was easier to keep up with versus the other one that is lagging behind a couple sentences.
they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that.
Carly in the chat asks, who do all these lawyers represent? The parties in this lawsuit are the O'Keefes in a variety of ways. So the O'Keefes, personal representative for the estate of John O'Keefe, individual family members, C.F. McCarthy's bar, Waterfall Bar, and C.F. McCarthy's like through parent company, Waterfall through parent company, and Karen Reed also has multiple attorneys. So it is Karen Reed, the O'Keefes, and 2 bars. And a number of the attorneys, Karen Reed has multiple attorneys on each call because she has multiple attorneys working on this case.
Needs to do in the next couple days to address any technological issues that are remaining.
And Rosenberg is one of the attorneys for Karen Reed.
So Attorney Rosenberg, in November, Attorney Waters.
And Attorney Rosenberg said, we thought we fixed a lot of these issues. If they don't tell us what the issues are, then we can't always help with that. A lot of you are like, where's Attorney Jackson? Jackson is kind of working in a consultant capacity with these attorneys. There are lead civil attorneys in this. Jackson is one of the additional attorneys, but he's not going to be on every single one of these meetings. And I wouldn't expect him to be because the other lawyers are kind of taking the lead in the civil case. Indicated
that the Reed team had sent out between 10 and 12 subpoenas.
That's correct,
and it appears you've resolved, at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as the Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor.
Everybody who was like, we're just talking about all of the discovery. Come back for Proctorness. Come on back. We finally locked in the deposition for Proctor. I bet that was one of the first ones. I bet that's one of the first ones they wanted to lock in.
His counsel's availability, and that'll be going forward in April. We have not yet scheduled other depositions, but we from the Reed side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon as we're able to coordinate schedules, which has obviously been daunting in this case.
So
Very
just
daunting.
so I understand,
Is
what
daunted.
subpoenas have been sent out?
That's the court
So
asking.
we've sent 2 subpoenas to Michael Proctor because there was additional information that became we became aware of. We've sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department.
I bet
we
they
sent a
did.
subpoena to the Massachusetts State Police.
I bet they
Sent
did.
a subpoena to Sergeant Good, as Your Honor said.
I bet they
We
did.
sent a subpoena to I don't know if I said the district attorney's office, but
No.
both us and the plaintiff sent subpoenas to the district attorney's
I
office.
bet they want their files too.
They're
not gonna get all of it.
Subpoena to Mr. Proctor's prior attorney in connection with his
Termination
appeal, just relating to this one particular issue that is relevant to the district attorney's office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but that's the bulk.
I don't even know if a DA's office would know how. They'd be like, what are we supposed to do with this subpoena for all of our things? Some of it's privilege because this does not happen. It's such a strange set of circumstances that in a civil case, it actually is relevant and matters to go subpoena the records from the DA's office, different than just getting them from the police department. Normally what the DA's office has is just the police department records, and you're like, go subpoena the police and they'll give you the records. This is it's just all so fucking strange. All of this. And I'm sure the DA's office is like, what do we even do here? Just give them everything. Just give them everything. Make the court order it so that you're protected and give them everything. Your Honor, do we have to turn all this over? Great. We think these things are privileged. Can you review them? If you turn them over, great. It's so much stuff.
Of them thus far.
It's so much
When did the
stuff.
subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
What?
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have.
Oh, shock me, shock me, shock me. Well, we thought they didn't have the documents, and now we're like seeing that they might actually have the documents. How much new stuff are they going to find? Also, you guys are going to ask because law nerds are smart as fuck. Look, if any of you just sat there and said to yourself, no, I'm not, shut up. How dare you argue with me? Yes, you are. Because how dare you? Yes, you are. Emily, if they find things that didn't come in at trial, what do they do? Here is the answer. Not much, because Karen Reed was acquitted. If Karen Reed was not acquitted, this would be a whole different thing. But if they get information that they did not have during trial, which may happen, I don't have confidence that it won't. But if it does, because she was acquitted, I think we'll hear about it, which is helpful to other criminal cases that are pending. But there's not a lot that can be done because she was acquitted. Other defense attorneys will take that and run with it. Does that make sense? So other defense attorneys will be able to say, but it's going to be the full Reed effect. Other defense attorneys will say, but what we saw in the Reed case is they asked for it. Everyone said it was everything. And then they got more, and then they got more, and then they got more. So it is going to have an impact, but because Reed was acquitted, they can't go back and be like, we should have had this evidence then. You're right, you should have. But there's not a lot to do with that. And then we've got all these lawsuits. So it really will come up in the context of all these lawsuits. Because when you go forward in the civil suit, The O'Keefes are saying that Reed caused the death of John O'Keefe. What's Reed's defense? We heard it from David Yannetti that she was framed. And so in the civil case, being able to show this came up in the criminal case, and we didn't even get this here, goes toward the defense argument that Karen Reed was framed. It all goes to that defense argument. Now, are other agencies watching this? I mean, the FBI. Maybe. But it will come up in the civil context. But can it undo anything in her criminal case? No, because her criminal case ended with her being acquitted. All right. Hopefully that makes sense. Let's continue.
Currently,
Canton. Oh, where were we? We left off with when did you subpoena Canton? Over the summer 2025. Have you heard anything? Bits and bops, but we haven't gotten everything we asked for. And then they said they didn't have it. And now it seems like they have it, but it seems like they didn't have it. But now all of a sudden it exists. Kind of like all that video that just appeared during trial 1. It's like, there's no video. Boop. Topic.
Discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston
Surprise
Police Department
topic.
go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor.
Do lawyers keep all this information in their head? Yes. They also generally have notes, but yes, you need to have all of this in your head when you are having this conversation. If you are a person that has remembered every song lyric of every song that you have ever heard, this would probably also work well for you to keep all of this in your brain before you have this hearing. Yep.
Proctor and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
Yes, Your Honor. Yes.
I certainly would, Your Honor. But here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now.
Right.
And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the...
Excuse me, Your Honor. They're just fucking with us. Your Honor, this is the fuckery. Here is the circle of fuckery that we are dealing with. We send a subpoena, it's ignored. Then we follow up and they want to confer. Then we've got to get whoever their counsel is or outside counsel or whoever on the phone. And then we confer and then they object. And then we try to deal with the objections and then they object again. And around and around and around and around.
Court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified.
Tell me more about Proctor's cell phone. Tell me everything about Proctor's cell phone. I'm going to back that up. Tell me everything about Proctor's cell phone.
Attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for two and a half.
Chat. I cannot believe what the fuck is happening. So we're going to listen to this again. Chat. We're going to listen to this again. Because what the attorney for Karen Reed is telling the court is that they went to the DA's office to get all the shit off from Proctor's personal phone. Remember, this is the added information from Proctor's personal phone because they got Proctor's work phone. Well, the feds got Proctor's work phone. And then they went through motions for like months and months and months and months to get Proctor's personal phone. And then the DA's office was told in the criminal context with the other cases, Miles King and the other cases, they were told, well, there's probably not going to be much there anyway because he had gotten a new phone. And then they were able to get to the iCloud. And remember, the iCloud dump was discovered, and the next motherfucking day, Proctor withdrew his appeal of losing his job. The next day. And now what we are being told is that Karen Reed's attorney went to the DA's office and said, hey, we're going to need all the stuff that you got off of Proctor's phone / iCloud. And we went over together the protective orders. There's a new motion about that was filed yesterday. Protective orders for the stuff in his personal phone. And so Reed's attorneys went to the DA's office and said, excuse me, you have something new. Please might I have discovery? And the DA's office went, that's Proctor's phone, go get it from Proctor. And so they went to Proctor. And do you know what Proctor said about the new phone? The new phone that you weren't going to get anything off of? Lost my phone. Lost my phone. I'm so flustered that George has jumped onto the desk. Hi, Georgie. George is like, no, the birds are outside. Yep, the birds. All right. So this is now, okay. Phone that happened during the Karen Reed case, gone. They get to the new phone. Proctor says, you're not going to find anything on it. They find everything on it. They give it back to Proctor and it's fucking gone. Some of you are asking, can they subpoena his iCloud account if anything is still there? Does anyone believe that the shit's still on iCloud? Right. If Brandon Bamfield's laughing at anyone, it's Trooper Proctor. Bamfield's like, well, at least I figured out how to get rid of my phone shit. But do you think it's still there after the whoops, it's all still there? No. But the DA has it. So Reed's team is like, okay, but the DA's office told us to go get it from Proctor. And Proctor's like, whoopsie doodle, we don't have it. It's gone. It is such absolute apparent fuckery that Proctor is destroying evidence. No, I'm not saying allegedly. Come at me, bro. You didn't just lose your fucking phone. Miss me. I do not believe you. I do not believe you for a single solitary second that this was a whoops, the phone is lost. I can't believe that and he would have gotten a notice to preserve. Like, when did he get the notice to preserve? Because Karen Reed sued him personally in the civil case in federal court, which this is going to have to come up there too. And he's a necessary witness here. So he would have gotten a notice to preserve ages ago. So now you're in full don't delete your shit mode with spoliation of evidence. And the fact that the DA's office has it, the DA, at least there's a remedy for it, that the DA's office is going to have to turn it over. But do we trust that the DA's office will do the right thing? I want to see these lawyers go absolutely code red WTF just on Proctor. It is so appalling and transparent and obvious. I shouldn't be stunned, but like, how does it keep getting worse? So no, Proctor should stay in the crosshairs. So Proctor gets a new phone. You're not going to find anything. Then they find everything. Then they give him back the phone and then the phone gets lost. Sure, Jan. Oops. Lost under a hammer. Lost on a military base. Did it buy a one-way ticket to Vietnam? Where's the phone? When's the last time y'all lost a phone, an iPhone, that you couldn't find? You're going to tell me it wasn't connected to Find My iPhone and that you didn't have location sharing on with like your sister who you were calling every day and updating all the facts of the Karen Reed investigation? Your sister doesn't have your location on Find My iPhone. You're not location sharing with your wife. You're not law enforcement anymore. So maybe you're just at home all the time. Like, what's going on? How are we losing an iPhone in 2026? Broken, yes. Lost? Huh. Weird. I got a text from a friend of mine, Judge Abby, the other day, and she's like, "Oh my God, you're in Evansville, Indiana. I forgot today was the day of the concert. Have a good time." I've gotten texts from friends that are like, "Holy shit, you're at Airport X. I'm at Airport X. Can we say hi? I didn't know you were traveling today." Maybe we need to redirect the energy of the TikTok psychic to find Proctor's phones. Maybe it would be a good use of energy. Maybe we just redirect the energy. Because I do not believe for a second this phone was lost. Kim Let's Chat said, can't they use tower data to find the phone? They might not have the subpoena power to get to it. I don't think the phone is lost. And when the phone's turned off, it will only show the last place the phone was. Well, the last place the phone was in your house. You're right. Chloe ate the phone. That's right. Chloe ate the phone. That's exactly what happened. Chat, the level of fuckery. Can you imagine? You can imagine. You don't need to imagine. How frustrated would you be if you're the Reed's attorneys? Also, are you surprised? Are you surprised at this point? Are you shocked? No, because of course, at least the DA's office has it. But what the fuck? It's just, the fucking audacity to just yeet your phone on. They need to throw all of the discovery sanctions at Proctor. Just throw everything at him. Just all of it. I don't think he cares. And after he's lost his job, I think Proctor has moved into full, like, no fucks given. What are you going to do? Sanction me? Fine. Sanction me? Fine. Fine. So fucking appalling. So appalling. I do not believe for a second that the phone is lost. I believe he said that. I do not believe it's the truth. Because I bet Proctor's here with like, what are you going to do to me? Well, sir, it seems like there's never been enough consequences. So maybe somebody needs to go find the consequences. This man thought he deserved his job back. Fucking lost phone. Do any of you believe him? If you do, please explain to me because I'd really like to understand. I would really like to understand. The spoliation of evidence is a civil sanction. It is a monetary sanction, and there can be other jury instructions, but it's not something that they can go and arrest him for. It's civil sanctions. And he's like, whatever, come after me for the money. I'd be real curious if his... I'm going to let that go. Emily, don't give people ideas. I would just wonder if he cares about monetary sanctions. And if it goes to trial, there will be a jury instruction saying that, you know, he lost his phone. The information they will get through the DA's office, the information will come to light. It is just going to cost Karen Reed's team time and energy to do it. It's just so wild. Everybody's like, oopsies, my phone's just lost. Ugh. I don't even know if Code Red does it with this because it's so beyond. It's just, I don't have words. I really don't have words. And also, isn't this exactly what we expect from Proctor? Isn't this just exactly what we expect? This is just his normal operating procedure, apparently. Corn Diggity in the chat said, holy crap, were you at the Offspring concert in Evansville last week? I was. My kids had never seen Bad Religion live. Griffin had never seen the Offspring live. Griffin had never seen my husband at a Bad Religion Offspring concert. It was a very good time. So, what's code apoplectic? We need a code Proctor fuckery. No, he doesn't get his own code. Let's keep going. I'm so dumbfounded by this, and I'm so mad. And yet, it's exactly what it is, isn't it? It's exactly what it is. All of you are just like, we need to code something. Yes, we'll go dark mode for a minute and just see what happens. We're just going to sit in the dark. We're in code timeout. We're just going to sit in the dark. Code 404. We're just going to sit in the dark. We're just code timeout. What the fuck?
Under 9C to try and get documents without burdening the court with motions to compel. We then,
I backed this up because I just needed to listen to it again.
Instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone after it was provided back to Mr. Proctor from the district attorney's office. In the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement.
2.5 months of discussion. 2.5 months of discussion with the DA's office. You've got to go get it from Proctor. They went to Proctor. Proctor's like, excuse me, I lost it. I'm just a baby. I lost my phone. Oopsie doodle. And then went back to the DA's office and was going back and forth with them for 2.5 months.
With the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities.
What the lawyer is saying is that this is costing Karen Reed a lot of money. This type of dumb fuckery just starts racking up the bill. A number of you that are just coming in are asking, can we see the judge? No, the judge is in Logo jail. So even if you could see the judge, he's in Logo jail. You can't see him. He's under a W. So no, we can't. Even if I moved me, we still can't see the judge because he's in Logo jail. So yeah, this is the worst. This is the worst.
To produce documents. The state police still haven't produced documents.
You should go after Proctor for sanctions, and he should have to pay for all of the attorney's fees for all of the extra time it took to get this because he yeeted the phone. It's full spoliation, and he had notices to preserve. There's no way he didn't. He had notice to preserve, and they should go after him for all the attorney's fees it took to track down the DA's office and do all of this fighting. 100%. The thing about civil attorneys is they won't let it go. Kind of like terriers. Like even if they don't do it this month, it will come up and it will not be let go. But it might take until the end of the civil case to do it.
Under the impression they'd been reviewing them for months. Just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to to do what they
start slapping people with paper. Counsel, hey counsel, now's the time. Just start slapping people with paper. Oh, 2.5 months, motion to compel, motion to compel, motion. Just start smacking people with stacks of paper. It costs time, it costs money, it's annoying, but you just have to start. You just have to start building a stack of paper. Because apparently this is just how it goes and nobody gives a shit. It's 2.5 months here. It's 2.5 months there. How is this okay?
They have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
Yeah,
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but
I'm also frustrated, Your Honor. The law nerds would also like to lodge for the record that they are also frustrated.
Why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case...
Just file them. I get how annoying it is. It's going to be annoying for this civil attorney to be that guy. You're going to have to be that guy. This is your job to be that guy. But you're going to have to file a motion to compel. And then the motion to compel is going to set for a hearing. And then the day of the hearing, you're going to come in and say, oh, Your Honor, so we filed the motion to compel. You set it for a hearing and then they gave it to us. And then they gave it to us. B2, good to see you. Yeah, that's exactly what's going to happen. Isn't it amazing? When it's like, oh, okay. I'm going to have to go to the judge. And then all of a sudden everybody does it. So weird when you escalate the problem, how it tends to solve itself. But it's not working if you're not filing the motions to compel. So just tap in the court. Be like, make it the judge's problem.
can I just be clear?
It needs to start moving on.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations.
That's not what he said,
I believe
counsel.
would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we
That's
get
not what the court
non-compliance
said.
from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not.
You can still, Lyndon said your client's name is Karen. Go to the manager. Exactly. It's time to be that guy. It's time to Karen out on the other attorneys. And the thing is, the court's not asking him to subvert the meet and confer. The court is saying, okay, but if you met with them and then you're hitting all these roadblocks and then they're not turning it over and then it's taking 2 months, 3 months, 4 months, 6 months, you should file a motion to compel. There's a reasonable amount of time, and 9C are the civil rules, for those of you asking, the civil rules about how you need to meet and confer. You don't just run to the court and be like, excuse me, we filed a subpoena last week and they haven't responded. That's not a reasonable amount of time. And you have to call the other side and be like, what's going on? The rules encourage the attorneys to try to sort it out. But much like a fight on the playground, not everything can be sorted out between the parties. That's why there's a judge. The judge comes in and says, both of you stop. When did you ask? Why aren't you giving it to them? Give me a date that you're going to get it done. The judge is there to be the referee of all this. And that's what's going to have to happen here.
Suggesting you ignore any of the rules. I'm suggesting you avail yourself
This is so annoying.
of the opportunity to use them. And I'm simply suggesting that the length of time that it has taken to resolve issues
It's too
that
much.
shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, I
This
agree
helps.
with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not
It sounds like you have numerous situations, counsel. It sounds like everything is a situation and not a funny GTL situation. It's not a Mike the situation. This is a full ass what the fuckery we have 404 situation. The situation is now. We are in the situation.
engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3.
I appreciate that you're in good faith conference. When it comes to Proctor, at least, where's the good faith coming back at you?
or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools, and we'll continue to do so.
Anything else?
Anything else?
Not for
the
me, Your
court
Honor.
says.
Okay, so why don't we all plan to get together?
Okay, let's just summarize real quick, because the civil motion here. Let's get back to our here. We'll go Audacity green real quick. The lights are gonna be so mad at me. Let's just reconvene real quick. What are we talking about? So Karen, they're at a status conference in the civil case. This was from February 3rd. Karen Reed's attorney, the other attorneys were saying they were having a hard time getting to some of the Karen Reed discovery because they couldn't open files in whatever service they're using digitally to exchange discovery, that there are going to be external e-discovery vendors to deal with it. And that's the direction that they are going. And then when they turn to Karen Reed's attorney and are like, what's going on your end? Where are we all at? Karen Reed's attorney's like, look, Your Honor, I would love to set depositions, which for those of you that are new law nerds, we don't talk about this a ton in civil cases, but we saw them in the Depp Heard case, right? The attorneys are all together. They sit down and they ask that person questions. It's like pre-trial. You ask all the questions you want to ask, even the ones that are objectionable. And then there's an objection. It's noted for the record. Oftentimes the party is required to answer, and then you sort out down the road what comes in and what stays out. It's trying to get to a resolution of the case by going through an extensive discovery process before it goes to trial. Some things just have to go to trial, but a lot of the times after everything comes out at deposition, you can be done. The difficulty is you do not want to go into depositions until you have the paperwork discovery, because having to try to get everyone back and ask the court, because there are rules and restrictions on depositions, ask the court to do an additional deposition. You have to show that new information came up that you didn't know before the deposition. Like, whoopsie, I forgot to ask this question doesn't cut it. But Your Honor, they actually didn't give us the discovery. They told us it didn't exist and now it exists. You might be able to go and then get an additional deposition, but it is not regularly done. It is not as easily done. So the parties want the discovery before the depositions. This makes perfect sense. You need to be prepared to ask them all the questions. To do that, you need to have all the information first and then sit down and ask. But what they're saying when the court says, why aren't the depositions moving forward? We can't go to trial until the depos are done. The attorneys are like, well, Your Honor, we can't do the depos till we have the information. The court's like, well, why don't you have the information? Why aren't you filing motions to compel so we can move along the deposition schedules? Because only one deposition has been noticed in this pretty extensive case. So the court wants to know why the depositions aren't moving forward, because you've got to move this forward towards trial. The parties and the attorneys want to know, well, until we have all the discovery, we can't set the deposition. So you see the circle that they're stuck in? So then when Reed's attorney starts explaining this, he's like, well, Your Honor, we went to Canton and Canton didn't respond. And then Canton did respond. And then they said they gave us stuff. And then they said they didn't give us stuff. And then they said they didn't have it. And then they said maybe they kind of have it. And then we might get it. And that was 6 months gone. And then Proctor got his phone back from the DA's office, his personal phone, the one that was like, whoopsie, there's all this information on it that his lawyer said there wasn't. And then his lawyer from the civil service appeal yeeted. And then he got a new lawyer, but he got his phone back. And then, whoopsie, his phone is gone. So then they go to the DA's office. The DA's office is like, we gave Proctor back his phone. Go get the phone from Proctor. They went to Proctor. Proctor, we need the phone. The lawyer's like, whoopsie, the phone got lost. And so now you got to go back to the DA's office and be like, now we need the discovery. We can't get it from Proctor because Proctor fucking lost the phone. Sure, Jan. And so we need to get it from you. And the DA's office is like, we can't give you this. And if we do give you this, there's all these restrictions on how you can use it. That's not how civil works. On and on and on. So the judge is like, what are we doing? This case is never going to move forward. Ghosts in the chat said, yeeted lawyer? No. The prior lawyer was the civil service lawyer. And once Proctor stopped pursuing the civil service termination appeal, that lawyer was no longer provided for him. He needed to go hire his own lawyer. So that had been a lawyer provided for him. It would have been through the union, his union. So no, the lawyer self-yeeted. The lawyer's like, whoop, we're out. Bye. So the judge is like, okay, everybody, when can we get this done? So the judge is going to set another hearing. Let's listen. Mm-hmm.
Together next Thursday at 4:00.
Come back to me. Figure this fucking out. Figure this shit out.
And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask all the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4:00? Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question, though. about the request for the intended depositions, are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose?
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right? Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
Thank you.
Okay, so for the record,
Your Honor.
for the record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produce to Attorney Diller.
Okay, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production came from their office.
All right. Thank you.
Your Honor.
Thank you.
Your Honor.
Yes, sir.
Anybody have anything else? Silence. One person speaks and everybody's like, well, actually.
With respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to have it, to be able to receive it. Otherwise, we can't just, you will not be able to receive it just via email. You'll need some type of technical capabilities to receive the actual documents. So we're happy to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Talk to the clerk. Show me what the fuck's going on here.
Thank you.
Thank you, Your Honor.
Thank you.
All right. That is the end of the hearing from February 3rd. We are going to now, because we are time travelers today. Welcome. We are now going to get to zoom to February 12th. So we are going to go to February 12th to see that hearing and what the status is of everything the court was asking about previously. So we are going to hop over to that hearing before we get to the hearing from yesterday, because I think, the background was helpful. Let me know if it's helpful to just go through all of them. I was trying to kind of lump them together. Let me know if the background is helpful to understand, because I think down the road when we see motions starting to pop off without the background of how frustrated everybody is, it's not going to make a ton of sense. So we are going to zoom to the February 12th hearing. And let's see if I can shift to the YouTube closed captioning that are a little bit larger and see if that helps. So let's go to the hearing from February 12th. This is the follow-up hearing before we get into the new issues. But good Lord, with the Proctor phone fuckery. I am so dumbfounded. I shouldn't be dumbfounded, but I am so dumbfounded that the response from Proctor is, oops, I lost my phone. Girl, come on. All right, we have a slightly smaller Brady Bunch set of squares today. At this point, the courtroom, we can actually see the judge is not in judge jail today under the logo. So let's go to court. From February 12th, 2026, in the afternoon, we have Attorney Rosenberg here at the bottom, Attorney Diller. We've got the Attorney David Hassett with other attorney. They have been doubled up on Zoom, the last Zoom.
Good afternoon, Your Honor. May I proceed?
All right ahead.
Good afternoon, everyone. The matter before the court is civil action number 2483-CV00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC et al.
Change that just a little bit so it's
Your
easier
Honor,
to see.
parties are all present via Zoom.
Okay, seems like we have at least one attorney for all parties.
At least one attorney for all parties.
Are we waiting on anyone?
No, we're not, Your Honor.
Okay, so let's talk first, Attorney Diller, about the status of the plaintiff's efforts
that's worse.
to access discovery that was provided by the defendant Reed.
As of 3:00 p.m.
The judge is the one pouring water. I couldn't change the color of the closed captioning. Hopefully it works. The judge is the one pouring water, like onto the microphone. Onto the microphone.
Your Honor, the newest load file was still loading and mapping to our system. And that's as of 3 p.m. today. It looks like it's working, but it is still loading.
All right, chat, you gave me another suggestion. I'll try to fix that
for the last couple
one.
days.
Let's see.
So that would be consistent with the court's efforts to try and access the information, because our IT department has experienced some issues during the download process.
Here we go.
In fact, in
thank you,
several
chat.
instances,
Chat, you fixed it.
Download.
Chat, thank you. To the person that said font opacity, thank you. I didn't scroll down far enough. Thank you so much. You fixed it. Null and void. Thank you. Appreciate you.
Failed after running for hours, requiring a restart. I mean, we have about 12 of the 15 files in the first batch, but you can't review any of the contents until all 15 files have been downloaded and combined.
Team Baker, huddle up real quick. Team meeting. It's not just us that can't get files to load. We were fighting with files for the last 2 weeks. And it's so funny to hear the court just being like, okay, so the files are still just in the spinny wheel of death. Great. We're trying to load it. It won't load. So the individual that sounds like they're the farthest away on this call is the judge, because he is the farthest away and doesn't seem to have a microphone real close. That is the court speaking. So they're also having trouble trying to get all the files to load.
So I guess who's going to speak on behalf of the plaintiff?
Court's what's happening?
I mean, on behalf of Ms. Reed.
I am, Your Honor, Attorney Rosenberg.
Okay, so what do you suggest everyone's supposed to do?
So just to be clear,
we need the files.
What Mr. Diller is describing is different than what it sounds like Your Honor just described. We've been working with the plaintiffs and their e-discovery folks a lot since our last status conference last week. And they are at the point where they have access to all of the documents. They have certain load files which provide certain types of metadata. The last additional piece of metadata they asked for, we provided, and that load file is just processing within the e-discovery software that they use. So they're not having trouble downloading it or accessing any of the documents. What we know is, according to Mr. Diller's office, as well as the e-discovery consultant that they're using, is that this latest load file appears, I won't say they've said this definitively yet, because they have not, but they've said that it appears that it provides what they need. So Mr. Diller's referring to the loading, which is fine, but it's not the same as not being able to download or access them. I've had lengthy conversations with all three other parties to confirm that everyone is able to access all of the documents. We're working through normal, issues when 1 million pages of documents have been requested and produced. But I don't believe that any of the other parties are having the kind of issue that you just described, Your Honor. And obviously, if you would like, we're happy to connect with the court's IT folks who are looking at these to address anything that you would like us to.
Well, no, that's all right. I appreciate the offer, but I mean, at this point, Attorney Rosenberg, it's not like I want to read all the documents. I mean, the issue is making sure everyone has access to them. Okay?
I figured, but I thought I would ask, Your Honor.
So, you know, I should have made a record of everyone that's here. So Attorney Diller's here on behalf of the plaintiffs. Who else is here on behalf of the plaintiffs?
I am, Your Honor, BB Fell.
Okay, anyone else? All right, and I see Attorney Halstag on behalf of CNC.
Plaintiffs are all the O'Keefe plaintiffs. And then we also have CNC, which is CF McCarthy's, The Waterfall, and then all, like, not CNC Music Factory. And then all of the attorneys for Karen Reed.
I see Attorney Hassett on behalf of Waterfall. I see. Who else on behalf of Ms. Reed?
Your Honor, Damon Seligson on behalf of Ms. Reed.
Your Honor, Thomas Tang on behalf of Ms. Reed.
They always try and tag team us all, right? With multiple appearances here.
And Your Honor, Sarah Shipley also for Ms. Reed.
Oh, okay. There's a new participant. Welcome, Attorney Shipley.
Thank you, Your Honor.
Do any of the other parties want to comment on their efforts to access, again, just the discovery that's been produced by Ms. Reed electronically? Okay. No takers. I think we have to try and...
He's like, what are we doing, everybody?
Judge, I was just going to add, excuse me for interrupting, David Hassett. I was just going to add, Judge, we have been on the phone as well with Attorney Rosenberg and his e-discovery vendor. And it appears that the remedy for our problem is going to be
more cowbell. More cowbell. More cowbell. More cowbell. More cowbell. I got a fever. Yep. More cowbell.
Different discovery. Instead of a PDF form, it's going to be in a TIFF form, which is going to be reproduced to us. And I'm
going to be in a TIFF form if we have more Proctor fuckery during this hearing. I'll just let you know right now.
The time frame for that to convert it to the new platform, which should be accessible to us, is middle of next week. And that is as of this morning, Your Honor.
Thank you. So, unfortunately, I anticipate this might be a problem going forward. And so I want to try and make sure we get ahead of it. So I'm going to order that all the parties participate in a conference regarding electronically stored information. And the purpose of that conference is for the parties to develop a plan relative to the discovery of electronically stored information. And you can take a look at Rule 26F2C for the issues to be discussed at that conference. And consistent with the rule, I'm going to order that the parties honor before the end of business on March 3rd, file with the court a plan and a statement concerning any issues upon which the parties can't agree. And the parties can include as well whether there are any issues remaining relative to accessing the discovery that Ms. Reed has produced so far. And we're going to have a Rule 16 a Rule 16 conference about electronically stored information 5th at 3 p.m. And I understand you may all think it's kind of overkill, but we've been dealing with this issue for too long, and I want to avoid the issue.
I don't think it's overkill, honestly. I don't think it's overkill because the judge is wanting them to move along, and they can't move along until everybody gets the discovery. And if they've gone a week from the last hearing, and it's like, okay, but all the files are still just spinning. All right, we need to figure it out.
Future relative to other electronically stored information. So now anyone else want to offer anything on those issues? Okay, so now let's talk about the depositions. The parties provided me, the parties identified, if you can believe it, 61 depositions they wish to take collectively. And
61 collective depositions. 61 collective depositions.
unfortunately, only 20 of those depositions were duplicates. So that's 41 depositions that have to take place. And it appears that Attorney Reed's attorneys are the only ones that have noticed any depositions, unless I misread the filings of the.
Here's the problem with 41 depositions. That for 41 depositions, which is a lot, you need all of the lawyers you see, plus the person being deposed and likely their lawyer. So you are now trying to schedule all of these attorneys, plus the person being deposed, plus that person's lawyer, trying to find time to do 41 depositions is bananas, because you need so many parties. It's wild. Hillary asked, do we know why Karen has a new attorney? She has numerous civil attorneys. So these have been her civil attorneys, but these are her civil attorneys. So new to the civil case, but not new because they have not changed since the civil case began. She's working with, I think there are 3 or 4 different law firms involved in the civil case on her side. Speedy and Turbo's mom says, why do all the attorneys need to be there? Because they're all parties to the litigation. So every party to the litigation has to depose that witness. They might not ask a ton of questions, but one person sitting down to be deposed is going to be deposed by the person noticing the deposition, the opposing party, and then the other co-defendants. That is the time to do the deposition for all the lawyers. You don't get to have one person sit down and be deposed by party A, party B, party C, party D, party E, party F. One deposition, all the lawyers have to be there. That's your time to ask questions. And if they choose not to go, then they don't get to depose the party. You pass.
Party. So have any of the other parties noticed any of the depositions? Okay.
No, Your Honor.
So
not for formal dates, Your Honor. We had previously.
I don't know when they're going to get all this done. They're not going to have enough time.
Some, but those were stayed and now aren't on our list.
All right, but I've only been on this case since November.
And already I hate all of you. I've been on this case since November, and I am concerned that nothing is moving forward. Mm-hmm.
That since then, there hasn't been one deposition that's been taken.
Right.
And
there's not enough time.
At one of the earlier court hearings, you're all doing nothing, and I'm not saying that in a negative way, but doing nothing about depositions, and you're doing it at your own risk. And I've said that in some of the other pleadings. See, we got to get some of these things moving along. And I don't want to have to keep having court hearings, but it appears I'm going to have.
Yep. You're going to have to handhold everybody.
Than I wanted to. Yep. So does anyone want to talk about any deposition issues?
No, Your Honor. For Ms. Reed, as you said, we've noticed every deposition that's on the notice that we filed with the court. They're scheduled roughly to begin in March. There's a lot of them, so I think we've got the outside is on July 1st, but there's not a ton of dates in between those dates. We've tried to put everything on the calendar in a way that works, understanding that there may be some that need to move around a bit. But just to give you a sense of, from a scheduling standpoint, where the parties are with just our depositions on the schedule.
I don't know when y'all are going to do all of this.
The problem that I see occurring is that if we don't get other depositions on the schedule, then it's just going to extend discovery too long. And you'll note to date, I haven't extended the discovery deadline. And it remains that discovery deadline of sometime in August. So I think the parties need to get together. Maybe you can use the benefit of all being on a Zoom for the conference about electronically.
The judge is like, you're all here now. Talk it out, everybody. Figure it out. Between now and August, there's not a lot of time. I already feel like I don't have anyone else. Maybe it's because DCI feels like it's right around the corner. I already feel like I have so much to do between now and August that I want to hurl. So to get done 41 depositions between now and August, and then you still don't have all the discovery. And this is what's going to push it, because they're going to start, like, push it real good. They're going to start coming to the court saying, Your Honor, we can't do the deposition of pick a witness because we don't have the discovery from pick a place that's been subpoenaed. And they're going to run into a jam of, we just can't get this all done. And the deadlines are going to get pushed. But the judge keeping that deadline creates that sense of urgency. Like, this needs to be everyone's priority. Get it done. Lyndon said, Your Honor, if they don't do their assignment, how can I do mine? Yeah.
Stored information to try and map out a plan for discovery. So I'm going to schedule a conference for March 31st at 3 o'clock, again by Zoom, as all these hearings have been and will be, for a report on the status of depositions and discovery, as well as any other discovery issues that may arise between now and then.
Oh, the foreshadowing.
Any issues with that date from anyone? Okay. Are there any other issues that the plaintiff would like to discuss?
Your Honor, as it relates to accessing the documents, which is what started this dialogue today, one of the
judge is sitting down here in the bottom corner square. That is the judge flipping the papers onto the microphone.
Issues that we have as it relates to the depositions is we want to have the benefit of being able to navigate those documents.
This is Attorney Diller speaking.
I can share with you that we were advised, based on what was sent to the court, that what was turned over in discovery was each of the 66 notices of discovery from the Commonwealth. When we issued our requests for documents, there were 37 requests with subparts. Request number 1 asked for the 66 notices of discovery. Request number 2 through 37, maybe there's an overlap, maybe there's not. Part of the problem we're running into is being able to figure out what's compliant with those requests and what's not. It formed a basis for us to have previously served a motion to compel. Specifically, we were requesting the load files, which we have since gotten, and which is what is continuing to be loaded so that they become more usable for us. But number 2 was we requested that we be provided some index about what was provided in response to the 37 requests that we have, so that we can at least understand if there are documents that we are expecting that are not forthcoming. We can move to compel them. If there are documents that there's no privilege logs been provided to date, so I'm not aware of anything that's being claimed as privilege. But we're just trying to navigate that discovery so that we can take these depositions and access the documents. So would the court be inclined to suggest that there be some index of those documents as provided?
Yes.
I know that there are.
Yes, index everything. Yes. Y'all work together and index everything. I'll say yes. Yes.
There is an index for each of the 66 notices of deposition. But as it relates to what was requested, it will take us time to match those up to figure out what's related once we have a usable access to them.
Your Honor, if I could respond to that.
Well, let me ask a question first. Attorney Diller, have you spoken with Attorney Rosenberg on the issue?
Attorney Rosenberg's face says not exactly. Attorney Rosenberg's face is giving not really, not so much.
Okay. All right. Go ahead, Attorney Rosenberg.
Okay. Everybody come on back. Everybody, you're listening in the background to a Zoom call of a work meeting that you never want to be a part of. I totally get it. But as Attorney Diller is trying to explain this, Attorney Rosenberg, the attorney for Karen Reed, is sitting there like, that's not, Your Honor, that's not exactly what's happening. Come take a look at his face as this is happening.
66 notices of deposition. But as it relates to what was requested, it will take us time to match those up to figure out what's related once we have a usable access to them.
Your Honor, if I could respond to that.
Well, let me ask a question first. Attorney Diller, have you spoken with Attorney Rosenberg on the issue?
Yes.
Okay. All right. Go ahead, Attorney Rosenberg.
So first of all, there's no motion to compel before you, Your Honor. And Attorney Diller's asking you to, quote, provide guidance. It's not guidance. What he's asking you to do is change what Rule 26 says about what, and Rule 34 says about what we have to do. Well, here's exactly what happened. Plaintiffs.
The girls aren't getting along. The girls aren't getting along at all. Excuse me, Your Honor, that's not what's happening. Your Honor, no. Negative ghostwriter. No. Not what's happening. And there isn't a motion to compel. So Rosenberg is like, no, let me explain. Nope.
Serve document. But this
Hang on, Attorney Rosenberg. Excuse me for cutting you off, but there's no motion. I don't want to have to hear these types of issues without the parties having spoken. All right? So
I agree.
What are you supposed to do under the rules? And if you need to come to court, that's what we're here for.
Understood.
But
understood, Your Honor.
Please communicate with each other.
And Rosenberg's like, no, we will follow what we're required to do in the rules and not anything else. But I imagine that Diller is not indexing things for them, so they're not going to index things for him. If everybody worked well together, then everybody would be able to do it. But if that's not the way they have it stored, they don't have to do extra work to turn it over. So you can have we've talked to your e-discovery people. Your e-discovery people can index it. We've been working with them.
As best you can. I'll throw that in at the end, okay?
Work together as best you can.
I don't need to respond if you're inclined to wait for a motion.
Any other issues, Attorney Diller, that the plaintiff would like to raise?
As it relates to the noticing of depositions, I appreciate that we provided a list today to the court, which totals 41 separate depositions between all the parties. And I appreciate that as of
Diller,
either yesterday or today,
Diller, what fraction do you break down your billing increments? Because I don't think I've ever met an attorney that speaks so slow. My brain immediately is just like, whoop, I'm out. He's like, nah, we bill in like 3-minute increments. Dude, you've said hello in 3-minute increments. The speed is killing me.
Reed team actually served notices, but to the extent that I'd ask for the court's indulgence as we move through and navigate this process on trying to accommodate the scheduling of them amongst the 4 parties. We intend to cooperate and deploy as many resources as possible.
Deploy what resources?
Get through all those depositions, but I just wanted to say that
you have to
those
cooperate.
dates that have been noticed as of today aren't dates that necessarily work with our calendars, and so we'll be working through that process before we meet next time.
I'm sure there are dates that aren't going to work for many of the attorneys, so I also anticipate experienced attorneys should be able to work out those issues and be reasonable.
The court, y'all need to act like adults. You have 41 depositions to do. You brought this lawsuit. Get it done. Experienced lawyers should be able to figure it out. Figure it out. The problem is, somebody earlier in the chat said maybe they just booped it all with their little like Canadian boopy finger. We're just talking about curling. But the difficulty I have found with civil that I hate is that once one party starts to draw a line, the other party is like, I'm going to take that line and drag you all the way to hell. And so if one party starts being like, I'm not indexing him, the other party is like, okay, well, if you're not going to work with me, I'm not going to work with you. And then they all stand there and they're like, I'm not touching you. The rules say I don't have to do that. I'm not touching you. I'm not touching you. And then they all just start to fight. If once one person starts it, it's like, oh, I'm sorry. I didn't realize this is how we were doing it. Okay, if this is how we're doing it, let's go. Sure, make my day. And then nothing gets fucking done. And I'm feeling like we're getting to the beginning of, okay, well, if you're not going to do this, we're not going to do this. It's brewing. It is brewing. Where it's like, well, Your Honor, these dates might not work for us. And when the judge has to say experienced attorneys can figure this out, it does not bode well. It does not bode well. Nina in the chat said, I'm Swedish, don't touch the stone. Right? The boop finger. It was such a boop finger. It was just like, boop. It was totally a boop finger.
Anything else, Attorney Diller?
No, thanks, Your Honor.
Attorney Rosenberg is actively trying to hold his words inside of his mouth. Attorney Rosenberg is literally trying to hold in all of the thoughts. Attorney Rosenberg, A, we love a stand desk. B, we can see you restraining yourself.
Okay. Attorney Olstag on behalf of CNC. Anything?
I have nothing, Your Honor.
Okay. Attorney.
If you're the lawyers for the Waterfall or CF McCarthy's, I think you just sit back and let them all fight, right? You're like, we're just here, Your Honor. We're good. This is between them. We're just the bars. We're just on the side of all of this. They're just like, nothing from us, Your Honor. We'll just follow their lead.
Hassett?
Judge, nothing further at this time.
Thanks. Attorney Rosenberg?
No, Your Honor.
Okay.
Your face says otherwise.
We'll see you all on March 5th. Anything else comes up, just get a hold of the clerk.
Thank you, Your Honor.
Thank you.
I'll see some of you on Tuesday. Well,
Right.
Yes, Your Honor.
all
Thank
right.
you.
Thanks very much.
Did you see Attorney Rosenberg's face? We'll see some of you on Tuesday this week. Mm-hmm.
Have a good day.
Thank you.
Okay, so just for the record, this matter is continued to February 17th, 2026 at 3 p.m. for that motion hearing. It's further continued to March 5th, 2026 at 3 p.m. for the Rule 16 conference and March 31st at 3 p.m. for the status conference. Thank you all.
Thank you.
Thank you.
All right. So see you next Tuesday, chat. Next Tuesday being yesterday, because, we have a TARDIS and we can time warp. We are going to take a moment and look at the filings ahead of the motion that comes to court yesterday. So let me just look at one thing before we start pulling those up, because we are going to take a look at that hearing and go back to live court in a moment. We are not going to go there just yet. All right. Everybody ready? Ready? Let's take this down. We're going to get to some motion practice first. And let me see. Sorry, guys. I'm just asking a question. All right. Let's pull up all those motions because these are now... Actually, let's summarize where we're at. Emily, let's get organized. All right. A lot has happened. Let's summarize where we're at. Then let's move into the next set of motions. As we covered the discovery conferences with the court and all the lawyers in the wrongful death case brought by the O'Keefes against Karen Reed, the Waterfall, C.F. McCarthy's, we see that there are discovery issues that are kind of boiling over. We have seen Karen Reed's attorney Rosenberg saying, Your Honor, this is the circle that we are stuck in. We send a subpoena, we get ignored. We reach out, we try to meet and confer, we get objections. We ask for things, they tell us that things don't exist, then we find out things do exist, and we are stuck in this pattern of not getting the discovery that we need, not getting responses to our subpoenas. And then we did see a couple motions to compel. We actually saw a motion to compel regarding Sergeant Good. But then in that hearing on February 3rd, Karen Reed's attorney Rosenberg drops the, oh, by the way, we went to the district attorney's office to try to get all that Proctor discovery from the personal phone that didn't exist. And then, oopsies, there's an iCloud account, that discovery. And the DA's office said, no, you need to go get it from Proctor. So then Karen Reed's attorneys went to go get it from Proctor. And Proctor's like, so that phone got lost? This is the second phone, remember? Because when we were going through the civil service Proctor termination appeal, Proctor told the district attorney's office in connection with his personal phone getting pulled into everything in the criminal cases of Miles King and other defendants, and we've watched some of those hearings, that he had gotten a new phone. And so he told the DA's office through his lawyer, you're not going to find much there. Proctor had gotten a new phone. In the meantime, there's not a lot there. And then the DA's office released in a footnote that there are thousands of text messages and videos and audio and photos and all of it because it was in the iCloud. And then the very next day, he withdrew his appeal to get his job back. And then his lawyer from that appeal also was like, and we're out, everybody. Good show. We're done. So that was the new phone connected to the iCloud. The DA's office gave Proctor back that phone. And then Proctor, through lawyers, tells Karen Reed's attorney, I lost my phone. So now Karen Reed's attorney is going back to the district attorney's office being like, okay, you told us to go get it from Proctor. And Proctor's like, oopsie doodle, I don't have it. I lost my phone. I lost my phone. So Proctor's phone is lost, and now they are trying to set depositions with all the parties, the O'Keefe parties, Karen Reed, and the two bars. With all the parties, they have 41 depositions they want to take. But the attorneys aren't going to take the deposition until they have the discovery. And so the judge is like, can we get all the document discovery done so that we can get to the depositions? Because we have a deposition cut off in August. How are you going to get 41 depositions done with at least 5 attorneys plus the witness? How are you going to get these 41 depositions done? So the court is now narrowing down on the attorneys and is like, look, I don't want to have a meeting to have a meeting, but if that's the way things are going to get done, then we're going to do it. And so the court has set subsequent meetings to try to keep this moving along. And the court's like, I am concerned. I've been on this case since November and nothing is happening. Remember, this case languished a bit at the beginning because Karen Reed was still going through the criminal trial. And so everything ended up kind of on hold while the criminal trial was going on. When the criminal trial resolved, then this case really started to pick up into the discovery because the criminal trial had resolved. And so as they are going through this discovery fight, then we get into the email issue. And this is a motion that Karen Reed's attorneys filed regarding the email issues. And we are going to look at all of this briefing together and try to figure out what is going on. And then we're going to look at the hearing about the email issue tomorrow. All right? That was yesterday. We're going to look at that today. I don't mean we're going to look at it tomorrow. Yesterday's hearing, we're going to look at today. I am trying to find the motion I wanted to pull up. Hold on. Where is our docket number? Why is that the wrong docket number? There it is. Okay. If you have heard of this issue already, no worries. No worries. Just thank you for no spoilers. If you have not heard about this issue yet, buckle up, because the girls are fighting and the girls are going to continue to fight. This is filed up here at the top, February 4th. So right before the hearings that we were listening to. I wonder if this is part of the reason that they were so mad. Memorandum of law in support of defendant Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. Oh boy. Defendant Karen Reed respectfully requests the court order plaintiff's counsel, Diller, to destroy all copies of an email that Reed inadvertently sent to plaintiff's counsel on December 16th. Oh boy. Reed accidentally replied all to an email on which she was BCCed, blind copied, which unintentionally included plaintiff's counsel on her otherwise privileged message. Don't BCC. Forward it. The reply all email directly related to Reed's legal representation and this case. Despite numerous requests that began 39 minutes after the reply all email was accidentally sent, plaintiff's counsel refuses to delete the email, temporarily sequester the message, or even seek the court's instructions. Therefore, Reed seeks an order requiring plaintiff's counsel to delete the message and any copies and recover and ensure deletion of any copies sent to his clients or anyone else. Look, don't BCC. However, it happens that things are inadvertently sent. Most lawyers have grace in this because it happens. Most of the time, lawyers will say, this clearly wasn't intended for me. We saw that it wasn't intended for us. We have not read it. It seems that Diller is taking the other tactic with, nah, you sent it to me, fuck you. Which is generally not how this works. So when we see the lawyers, this motion was filed February 4th. We have just watched hearings from February 5th and February 12th. I'm wondering if this plays into the lawyers not being happy with one another. They let him know 39 minutes later, hey man, our client accidentally replied all. It's clearly about the case. Can you just delete it? Normally what would happen there is, hey, we haven't even looked at it yet. Absolutely, we'll delete it. It happens. This is, this is booping the stone. This is not how this works. These are normally sorted out together. Nikki said, but it wasn't brought up at the hearings. No, it's brought up at a hearing that is set for yesterday that we're going to look at because motion practice needs to happen. The lawyers tried to work it out together and now they need to ask the court, but these motions weren't set for hearing yet. You have to wait until this one has a hearing. So you still have to have a motion, an opposition, and a reply, and then a hearing. So it wasn't on the docket yet. Despite numerous attempts That began 39 minutes after the reply all email was accidentally sent. Plaintiff's counsel refuses to delete the email, sequester the message, which is the appropriate thing. Hey, look, I'm not saying I'll delete it. We won't look at it. Nobody will look at it. We will keep it apart. And if the court, we'll let the court sort it out, which would be the next step. Or even seek the court's instructions. Therefore, Reed seeks an order requiring counsel to delete it. Analysis. On December 16th, 2025, Reed's undersigned counsel sent an email to plaintiff's counsel and BCCed Reed. They're going to say blind copy. I'm going to say BCC in all of this. So she would be aware of his email. Forward. Fire and Ice. Why not just delete it? I don't know. We're going to read the opposition. I don't know. I don't know why not just delete it. I can't be helpful. We're going to read all the motions together. So we're going to read all the motions and then see the hearing. I know. We've grouped it all together. So instead of waiting for the answers to trickle in, we get to see it all at once. I'm very excited. I know. It's like binge watching Netflix. We've got all the motions and the hearing. I'm excited too. So December 16th, Reed's counsel sent the email. Reed was BCC'd. Reed replied to all. Reed mistakenly replied all to the email to share her thoughts on the legal issue that was the subject of the message, which meant that plaintiff's counsel was inadvertently included in her response. 39 minutes later, another of Reed's attorneys replied all to Reed's email, informed all recipients, and particularly plaintiff's counsel, that the email had been inadvertently sent and instructed counsel to delete it without reviewing the message. Worst feeling ever. Worst feeling ever. Like pit of your stomach, like holy shit, that sucks. This would normally just be either we'll sequester it, we understand, or no problem, we'll delete it. This is not, shit happens, but it's not meant for you. It's obviously a mistake. It's obviously not meant for you. Come on. So, Reed's counsel, Reed's counsel replied all and instructed plaintiff's counsel to delete it without reviewing the message. This is not when it happens, that's generally what happens. Reed's counsel then followed up shortly thereafter, reiterating the instructions and requesting confirmation that plaintiff's counsel had complied. Instead, plaintiff's counsel suggested he would not. Despite the obvious context clues, he claimed that the email from Reed had appeared to be directed to him. That somehow Reed's mistake, corrected minutes later, resulted in some undefined waiver of attorney-client privilege. Reed's counsel followed up with plaintiff's counsel multiple times, explaining counsel's obligations under the rules of professional conduct and case law, but to no avail. Plaintiff's counsel refused to delete the message, even sequester it, or seek the court's instruction. Oh boy. Becky RN, you and lots in the chat have said, was it not attorney-client privilege? Here's the thing. If you are in a group text or a group email thread with people who are not the client, it is not privileged. So the argument would be, I don't agree. The argument would be, she replied to all. That takes away the privilege because you have included non-privileged parties on the email. The argument on the other side is, clearly that was an inadvertent mistake. It was clearly not intended for you. She did not intend to share it with you. This was not a waiver of privilege. This was an error. Obviously. And we told you it was an error. And it seems that what he did was to double down and say, no, it seemed directed at me. Okay. What did she say about you, bro? Like, are your feelings hurt? It seemed like it was directed at me. I don't know what's in this email. But why do you think it's directed at you? Did it start with like this motherfucker? I want to know. I'm just speculating. recklessly and wildly. How did you think it was addressed to you? Did it start with, Dear Mr. Diller, GFO? Like, what? Why do you think it's directed at you? And we don't have the email. The court will, I'm sure. We don't have the email. So we can't know why he thinks it was appeared to be directed at him. Talking about you doesn't mean it's directed to you. I can imagine it might have been directed to him. It doesn't mean it was emailed to you. He thought it was directed. He said it appeared to be directed to him. Okay. Reed's attorney said, bro, no, stop it. The motion goes on to say, although most cases regarding inadvertent disclosure involve an attorney accidentally producing in discovery a document that should have been withheld. By the way, sometimes that happens and you can't unring that bell. An attorney accidentally producing in discovery a document that should have been withheld, Massachusetts courts have faced this issue before. Specifically in 2010, Judge Fabricant? That's an interesting last name. I don't know why I'm so fascinated, but I'm like, it's so close to fabricated that it's wild. Either way, Judge Fabricant decided that a client who replied to an email to opposing counsel after being BCCed had not waived attorney-client privilege. See the case, 2010, with the key site. In that case, the judge applied the standard that would apply in a more common scenario. A client does not lose the benefit of attorney-client privilege for an otherwise privileged communication through inadvertent disclosure. Ding, ding, ding. Through inadvertent disclosure, if client proves that client and counsel took reasonable steps to preserve the confidentiality of the particular communication. So where do we go with steps to preserve? Again, the lawyer shouldn't have BCC'd Karen Reed. Should have just forwarded the chain and said, FYI. Shouldn't have BCC'd. That's on the lawyer. Should not have BCC'd. Because BCCing, I wonder if Diller's going to argue that the lawyer did not take reasonable steps to preserve the confidentiality by using BCC. Were reasonable steps taken to preserve the confidentiality of the communication? And does BCCing her go beyond that? The court found that the client's transmission of communication to opposing counsel was obviously unintended. His mistake was of a type that is common and easy to make. Indeed, there may be few email users who have not on occasion used the reply all function in the manner they later regretted. Right. Wasn't there one that just got memed around the internet where somebody like BCC'd the entire college? There was one. You guys, we're just friends here. How many people are on live? Oh, there's 12,000 of you. It's okay. We're still just friends here. Bring it in real quick. Bring it in real quick. Bring it in real quick. Someone at the DA's office ages and ages ago figured out how to send a fuck you, I'm out email to the entire office. I don't even know how they had access to do that. I didn't even think you could email the entire office, like the entire office. Everyone in the office, a fuck you, I'm out email. But when I got in the morning and opened up email, I was like, oh, no. Like, A, how did they do that? B, how did they do that? C, holy shit. Holy shit. It was wild. Have you guys ever had this happen? Have you ever had this happen? Yeah, where you're just like, oh, buddy. It was a very intentional deuces. And then I'm like, I don't always check my email first thing in the morning, especially if I'm going to court. But did you guys check your email? Holy shit. Holy shit. You guys, we should print it out just in case they figure out how to delete it off the server. Somebody print it out real quick. Print it out. Somebody's going to find a way to yoink that back off the server. Get it. Wild. I didn't even know they could do that. And yet, there it was. This just got memed because somebody, was it college? that had like accidentally replied to all or something. I've seen a couple reply all memes around the internet, but reply all can go askew. That has happened. And here we are. The case law that Reed's team is citing says that the court highlighted the fact that counsel noticed the error quickly, immediately alerted his opponent, and demanded deletion. The court also explained that in this case, there were facts that supported a potential waiver, primarily that the same error had occurred and the disclosing party had not filed a motion to recover the email until much later when the opposing party attempted to use the email. But even with those countervailing facts in that matter, on balance, the court still explained that as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. Is that what we have here? Is that what we have here? Maybe. So, if this reply all was clearly inadvertent, shouldn't it just get deleted? Yeah, it should. Yeah, it should. Here, they go on to say, Reed sent the email in question at 2:28 p.m. and her counsel notified all recipients of the inadvertent message at 3:07 p.m. This is the first time this issue has arisen in this case, and Reed is now serving this motion promptly after the message was sent. Thus, this is a clearer case than in Charm, the case that we were just talking about, warranting the same result, a finding that the email is privileged. Reed respectfully asked the court to order plaintiffs to delete the message and any copies thereof. Respectfully, Reed's attorneys, all of them, dated January 9th. So Diller responds with an opposition. And in that opposition, come back, opposition. Diller opposes the motion. These were all docketed February 4th. Why did they hit the docket so late? Because they were filed before that. This one was filed January 22nd. The other one was filed January 9th. So these didn't hit the public docket until February 4th. That's not the file date. Please note the correction from the last motion as well. I wonder why it took them so long to get docketed. All right. Plaintiff's opposition to defendant Karen Reed's motion for an order requiring plaintiff counsel to destroy inadvertently produced communication. Plaintiffs respectfully submit this memorandum of law. Yes. Plaintiff, I flipped the parties in my brain real quick. I was like, wait a second, what? Plaintiffs, O'Keefe et al., submit this memorandum of law in opposition to Karen Reed's motion to order them to destroy the email. Defendant Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel.
The FBI!
No!
Bruh.
What? Like what? What do you mean? They cited case law showing that that's generally the result, warning that that's generally the result, and they didn't argue impropriety. They said delete it. Why aren't you deleting it? I mean, I didn't say it was nefarious. Why are you saying that it's nefarious? They didn't say impropriety. They said delete it. Impropriety, you say? Defendant Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. Reed possesses the burden of proving that the email communication in question is protected by attorney-client privilege, and that such privilege was properly preserved. Plaintiffs contend that any applicable privilege was relinquished when Ms. Reed responded to opposing counsel, because Reed and her team failed to adequately mitigate the clear and avoidable risk of inadvertently disclosing confidential communications. In addition, even if the privilege is deemed to apply, plaintiffs are not entitled to retain and utilize the email communication. In addition, they say, even if privilege is deemed to apply, plaintiffs are entitled to retain and utilize the email communication for impeachment purposes should Reed provide testimony inconsistent with her prior statements. Oh boy. That is going to get spicy real quick. Oh boy. Excuse me. She emailed me, and that email was to me, and I have the right to keep it. And even if it's privileged, I get to use it for impeachment. That's what they're arguing. What the fuck is in this email, right? I don't want to recklessly speculate on what's in the email. But what's in the email? All of us knowing what's in the email absolutely violates the point, right? Maybe one day we'll know. Put an asterisk. One day maybe we'll know what's in the email. Relevant background. During a status conference on November 21st, the parties convened pursuant to Rule 9C at the direction of the court regarding plaintiff's contention that defendant Reed failed to provide a proper response to plaintiff's interrogatory number 1, seeking the factual basis supporting Reed's third-party culprit defense as required under the rules of discovery. Okay. Interesting background. During the status conference, the court said, have a meet and confer conference. Y'all talk amongst yourselves. The court's not going to solve this. If you think Reed didn't answer the interrogatory, y'all sort it out. On December 15th, plaintiffs filed a motion to compel further answers to interrogatories from defendant Reed together with Reed's opposition and plaintiff's reply. The same day, plaintiff's counsel served Reed's team of attorneys via email with the motion to compel 9A filings, including plaintiff's reply brief. The following day, on December 16th, Reed counsel responded to plaintiff's email, denying the allegations in plaintiff's reply brief and seeking immediate clarification. What number is the reply brief? Dockets 58 to 58.6. Hold on. I need to make a note. Y'all, chat, do we need a side quest? Do we need a side quest for context? Let me see if I have those. I think we need docket 58.6. Hold on, let me see if I have it. Right? Chat's like, yeah, we need a side quest. What is in the reply brief? I've got docket. Let's see. That's docket 67. 67. This is only part of docket 68. I do not have. Oh, wait. No, that says 58. You guys, sometimes you get to watch it in real time when my brain flips things around. 58 to 58.6. Hold on. Where is, okay, 57, 59. How do I not have 58? All right, let me go look for 58. Side quest. I feel like this is a worthy pursuit of our time. Give me 1 second. Let me go pull. Let me go see if I can grab this docket real quick. I think I can because, let me just go. It's going to take me a second, chat. I normally don't pull things in real time, but I do think it is a worthy pursuit. And all of you have agreed that it's a worthy pursuit. We don't often side quest, but when we do, it's always a good time. All right, let's go grab those dockets. Wait, why did I pull up the wrong? Yeah, there we go. That's the right docket. Okay. Give me 1 second. We need to be in. All right. Let's grab the docket real quick. Thanks, chat. In real time. in real time. What do we need? We need that reply brief that is supposed to be in the realm of 58.6. All right. At least we don't have to scroll too far. 58.1, 58.2, 58.3, 58.4, 58.5, 58.6. Notice of filing, affidavit of compliance. Let's see. What do they say here? On December 15th, plaintiffs filed a motion to compel further answers. On the same day, plaintiffs' counsel served Reed's team an email with a motion to compel Rule 9A. The following day, Reed's counsel responded to plaintiff's email denying the allegations in plaintiff's reply brief and seeking immediate clarification regarding the statement that, quote, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer cited by Ms. Reed, but have also stated publicly that she has evidence to suggest John O'Keefe was killed inside the house, Exhibit 1. Oh, damn it, Emily, keep reading. It might be attached as Exhibit 1. Unbeknownst to plaintiffs, Reed's counsel apparently BCCed Reed to the subject email chain before sending the response. All right, let's see if it's in Exhibit 1. Oh, the email's in Exhibit 1. Oh, okay. All right, let's go to the email. Mark, in your reply brief filed with the court, you state, quote, in doing so, Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Ms. Reed, but also have stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. They have stated that. I don't know about the leaks, but they have stated that they have evidence to suggest he was killed inside the house. They do. We deny leaked evidence. Please identify your Rule 11 basis for making this claim, as we think this needs to be cleared up immediately. Okay, that's the email. That's the context. Let me see if I can find that reply brief. Oh my God, the lines on the docket are mismatched to where the docket numbers are. And my brain is like, meh. All right, we're going to switch real quick to the plaintiff's reply brief and just skim it, because I promised a side quest and we are side questing away. However, it's really helpful that they put the subject email in there, because now at least we have some context before we get to the hearing about all of this. This is just a side quest from plaintiffs. Oh, that's not gonna play nicely with me because I didn't download it yet. Plaintiffs reply to defendant Karen Reed's opposition to the motion to compel further answers to interrogatories. After a failed Rule 9C conference occurring on November 21st, 2025, plaintiff moved to compel Karen Reed's answers to interrogatory number 1, which seeks the basis or all facts supporting the subject of Reed's affirmative defense number 2, footnote 1. Before defendant Reed answered the complaint, plaintiff propounded an interrogatory to Reed on September 19th, 2025 to ferret out the basis for Reed's public, not under oath proclamations that she knows John O'Keefe was killed in the house and by who. Then on October 25th, 2025, Reed answered the complaint and, as expected, pled that John O'Keefe's injuries, death, were caused by the acts and omissions of third parties for whom Reed is not responsible. See docket number 44. Okay, great. Defendant Reed seeks to argue that the motion is moot when she attempts to circumvent the rule of civil procedure by adding 4 new sentences to her already defective interrogatory number 1. Oh boy. Such supplemental answer articulate the following new statements. The credible evidence indicates that he was beaten inside the home at 34 Fairview Road in Canton, Massachusetts on the night of January 29th, 2022, and died as a result. The individuals inside the house during the time period surrounding Mr. O'Keefe's death also took actions to suggest wrongdoing, including tampering with, destroying, fabricating, and manipulating evidence, all in an effort to direct blame towards me. Based on the information and evidence available to me, I believe that one or more of the occupants of the house at 34 Fairview, Canton, during the early morning hours of January 29th, 2022, caused Mr. O'Keefe's death. I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. The answer inclusive of those 4 new sentences is not complete or not compliant with the rules and purpose of discovery. Massachusetts Civil Rule Procedure 31AC9 directs that when an interrogatory calls a party to state the basis or state all facts of a particular claim or defense, the party shall provide a substantial summary of the factual basis. Here, they say, Defendant Reed's original answer together with the supplemental answer does not comply with the rules. Defendant Reed cannot make blanket conclusory statements like the credible evidence indicates. I don't disagree with that. You can't just say because I say, you have to say because this. And that is an issue. You have to lay it out. So, thank you, Miguelina. So conclusory statements are improper, fine. The individuals inside the house during the period surrounding Mr. O'Keefe's death also took actions that suggest wrongdoing. I mean, she laid out the facts for that. They go on to say Defendant Reed and her team have engaged in public media campaigns and freely spoken publicly without the consequences of providing under oath testimony. In doing so, Reed and her team have not only leaked evidence that now appears inconsistent. Okay, but what though? You can't just say it either. You can't just be like leaked evidence and inconsistent and blah, blah, blah. Like, I know you are, but what am I? Your Honor, Reed's team did not give us specific facts and they leaked evidence based on, because I said it. Okay. Defendant Reed and her team have engaged in public media campaigns and freely spoken publicly without the consequence of providing under oath testimony. In doing so, I'm waiting for Reed's team to respond, Google me. Google me. Reed's team does need to say, based on all of this, this is what we are asserting our claim based on. Fact. But also, they're coming in here saying, well, she said all this shit publicly. What shit did she say? In doing so, Reed and her team have not only leaked evidence that now appears inconsistent with the under oath answer signed by Miss Reed, but have also stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. Plaintiff was not a party to the criminal matter and had no rights to impede the criminal investigation and prosecution. Whereas defendant Reed and her team had 3 years head start on gathering evidence, plaintiff is eager to learn what defendant knows so it can secure evidence to narrow the issues. That's a fair request. Throwing shade's not going to help. Like putting in a whole paragraph of because fuck you, that's why isn't going to help. But yes, if you have evidence to suggest that John O'Keefe was killed inside the house, you need to provide it. Fair. But also, an entire paragraph of I'm not touching you isn't going to help. Okay, so this is the reply that pissed off Reed's team, being like, well, what are you saying? What do you mean? What have we said that is inconsistent with the under oath answers? What is it? Okay, so then we get back to the motion at hand. We're going to swoop back to the motion at hand. Back to where we were. We are back from our side quest. All right. Reed's team is like, what are you talking about? And what are you alleging that she said publicly that's inconsistent with her signed answer to interrogatory? What do you mean? What do you mean? Just full Jennifer Lawrence. Hot ones. But what do you mean? Okay. So that is the context surrounding the emails. Great. The girls are fighting over interrogatory answers. The plaintiffs say that Reed has made statements publicly that are inconsistent with her sworn statements. Reed's team said, bro, what are you talking about? And then all right. The following day, December 16th, Reed's counsel responded to plaintiff's email denying the allegations. Reed was BCCed. Approximately 46 minutes later, Reed replied to all email participants with factual allegations that are relevant to the aforementioned motion to compel filings and the subject matter of the email chain. Oh boy. Just Call Me Hen in the chat said, what sworn statements? The answers to the interrogatories. Those are sworn answers. They were the bullet points we just went through. Those are the sworn answers. So, the sworn answers are, they say, inconsistent with what she emailed. Okay. Jayra in the chat said, so boring. I don't know what's boring. This is the fascinating part of civil litigation. Everyone's fighting, everyone's mad, and everyone's accusing each other of lying. I'm fascinated. Because now we've got an email that the plaintiff is saying contradicts the sworn interrogatory answers, which would be a real big deal. Like a real big deal. If the email contradicts the sworn statements in the interrogatory answers, that's a real big deal. However, I don't know if I trust anyone to accurately represent what's happening here. I don't know. I don't know how much faith I have that everyone is saying it as they see it. Because we just watched a hearing where Diller's like, no, we've spoken with plaintiff's counsel, and plaintiff's counsel's face said, the fuck you have. So I'm not quite sure if I'm giving everything a big old fistful of salt at this point. So Reed replied to all, they say with factual allegations that are relevant to the motion to compel filings, because the plaintiff is saying, you didn't answer all the questions. Answer the question, Claire. You didn't answer the questions. And Reed's team is saying, I answered the fucking questions. I told you everything in the questions. What else do you want me to say? And they're coming back saying, because what you said on, well, they didn't say where, what you said publicly contradicts. And Reed's team came back with, show me. Show me what we said publicly that contradicts then. And then they came back with, answer the question, Claire. And then apparently Reed emailed with something that does contradict it, they say. 46 minutes later, Reed emailed all, replied to all, with factual allegations that are relevant. Plaintiff's counsel read the email response before recognizing that it may have been sent inadvertently, and prior to receiving any notice from defense counsel regarding same. The content of Reed's email response was inconsistent with her previous under oath positions in the interrogatory that is the subject of the motion to compel, footnote 1. Plaintiffs will provide the court with a copy of the subject email response for in-camera review at the court's request. Oh, fuck yeah. Excuse me, court clerk, I'm going to need that email. I'm going to need that email immediately. If I'm the research attorney, send me the email. Send me the email immediately. Give it to me now. I want to know what's in the email. How did he not see who the email replying was from? Like, what email program are we using that you don't see who the email's from? Unless it's just like, are we just like sitting in Gmail and it just like pops up next? Yeah, if I'm the judge, I'm asking for this email immediately. The next day, on December 17th, the court issued an order addressing the parties' discovery motions with a request that the parties attempt to narrow areas of disagreement. With respect to plaintiff's motion to compel, the court noted that Ms. Reed's counsel is requested to suggest to the court how to reconcile the position that there is nothing further for the court to compel with the information in the 4th, 5th, and 6th paragraphs on filing 58.1, page 2. So plaintiff is saying, you have not answered all the interrogatories. Reed's team is saying, we've answered all the interrogatories. Plaintiff is saying, no, the fuck you haven't. And Reed's team is saying, yes, the fuck we have. On or about December 24th, Emily, do lawyers have any life balance? No. I am still trying to reclaim balance because my profession has deeply broken me. On December 24th, 2025, at the request of defense counsel, plaintiffs agreed to hold their motion to compel in abeyance to serve Reed with supplemental interrogatories footnote 2, rephrased to specifically articulate all facts forming the basis of affirmative defense number 2, to which Ms. Reed would respond as required by Superior Court Rule 30A. Plaintiffs agreed to withdraw their motion to compel if Reed provides an acceptable response to the supplemental interrogatory. These need to be done before deposition. You can't just respond because reasons. Footnote 2. Plaintiff's interrogatory number 2, quote, state all facts forming the basis for your claim that plaintiff's damages arising from the death of John O'Keefe were, quote, caused by the acts or omissions of third parties for whom Ms. Reed is not responsible as set forth in affirmative defense number 2. They need to state facts. What tangible facts are you relying on to prove that you are not responsible and that something happened in the house? Name them. Just list them out. This is what they are fighting over in those interrogatories. Argument. Defendant Reed's implication that plaintiff's counsel has failed to fulfill their obligations under the applicable rules of professional conduct and case law with respect to Reed's email response has no merit. Okay. Plaintiff's counsel has not disseminated, leaked, or other... Excuse me, Your Honor. They're the problem. Not us. Your Honor, they're the ones that are leaking shit, not us. Okay. The deflection is just, why are we just deflecting in the middle of this argument? Your Honor, plaintiff's counsel has not disseminated, leaked, or otherwise acted unethically in any way with respect to the subject email. No one said any of that. What they said is that under all the guidance, when you get an email that's clearly privileged and not meant for you, at the minimum, don't read it and say that you will keep it separate and apart from everything else and not disseminate it to anyone else, and then get the guidance from the court. If you are going to refuse to delete it, most lawyers would just say, clearly this is between your client, not meant for me, don't let it happen again. Like, that's not what's happening, because I think what Diller is arguing is, obviously, this is not privileged anymore because you sent it to me. Like, you emailed. Why the fuck would Karen Reed be emailing you directly? That should red flag everything. Either way, they say that they didn't do anything wrong. They say, despite Ms. Reed's contention, plaintiff's counsel is under no obligation to destroy the communication at the direction of defense counsel or to affirmatively seek the court intervention. You sent it to me. Whereas Ms. Reed has the burden of proving that the contents of her email response were privileged and that she neither intentionally nor unintentionally waived any such privilege at the time of her reply. I mean, do the context clues of the email indicate that she thought she was emailing you? We don't know. We can't assess that. Furthermore, even if this court finds that Ms. Reed did not waive any privilege, plaintiffs are permitted to retain and use the subject communication to impeach Ms. Reed in the event she provides under oath statements inconsistent with the statements in the email. I'm curious if the court's going to do that. Defendant Reed, they say, waived any privilege with respect to the subject matter of her email response. But is there anything to show that she did anything beyond reply to all and that she intentionally tried to email you? Like, I still need to see the whole email chain. How did this happen? Like, how did the... I'm scrolling down to the email real quick. Because I wonder, but it looks like the email was from Reed's attorney Seligson. And then Reed responded, and I guess replied all, and it went to everyone who was CC'd, not just back. If she had just responded back, it would have just gone to Seligson. But the reply all just got everybody? All right. Continuing on, we went through the relevant background. Where are we? Argument. Your Honor, we don't have to do anything. They have to prove. They have the burden of proving it's privileged. They have the burden of proving that we shouldn't use it. It's their burden. Defendant Reed waived any privilege with respect to subject matter of her email response. They say, in order to show that a communication is protected by attorney-client privilege, the party asserting the privilege must demonstrate, 1, the communications were received from a client during the course of the client's search for legal advice from their attorney in his or her capacity as such. Obviously, they're her lawyers, and if she's talking to them about interrogatory responses, she's talking to them about legal. The communications were made in confidence. And 3, the privilege as to these communications has not been waived. They bolded that part. They are then citing case law that says, quote, because the attorney-client privilege often deprives the court of relevant evidence, it is strictly construed, and it is the client's burden to establish its application to a particular communication. The existence of the privilege and the applicability of any existence of the privilege is a question of fact for the judge. Here, they haven't addressed the case law from the other side. Here, unlike the typical scenario involving the attorney's accidental production of confidential materials, Miss Reed herself chose to share her opinions on the legal issue that was the subject of the email chain. I wonder what else she shared her opinions about. Miss Reed herself chose to share her opinions on the legal issue. Well, we now know what the legal issue was. They're talking about if John O'Keefe was killed inside 34 Fairview. That's the subject matter they're discussing in those emails. Or, I guess the other interpretation is they're discussing whether Reed leaked information, because that's what her attorneys were denying. So he goes on to say Reed herself chose to share her opinions on the legal issue that was the subject of the email chain when she responded to the group. Regardless of whether Reed's email response was inadvertent, the court should find that Ms. Reed waived privilege due to her failure to take reasonable precautions to prevent the disclosure of privileged communications. The SJC, Supreme Judicial Court, held, quote, the modern trend has moved towards a principle that the privileged status of a communication or document is not lost when an attorney and client take reasonable precautions to ensure confidentiality, but, for example, a privileged communication is nonetheless overheard. In support of her motion, Defendant Reed relies exclusively on the trial court decision in Charm, in which Judge Fabricant held that a client's accidental transmission of a reply all email communication to opposing counsel did not lose its privilege. While plaintiffs concede that the general circumstances in Charm are analogous to the present dispute, Defendant Reed and her legal team conveniently disregard the clear message from Judge Fabricant, warning future litigants of the preventable risk taken by Reed and her counsel here in finding, quote, well, at least they've gotten to responding to the case law. Quote, the question is close. The judge cautioned, Cohn's counsel's practice of sending him a BCC of emails to opposing counsel with a CC to co-counsel gave rise to a foreseeable risk that Cohn would respond exactly as he did. In sending his response, Cohn would have to have known what he was responding to, but nevertheless failed to take careful note of the list of addresses to which he directed his reply. On the other hand, a client who seeks to preserve the privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and should avoid practices that exacerbate risks. The letters get all mixed up in that word for me, and I always pronounce it wrong. Here, and this is in the charm case, here it appears that both client and counsel were less vigilant than they might have been. Okay, look, don't BCC. Fair, but also this level of fight is just unusual. It goes on to say, the ruling in charm, they and others should take note. Reply all is risky. So is BCC. Further carelessness may compel a finding of waiver. It doesn't seem that this has ever happened again. It doesn't seem that this had happened before. And it does in fact seem that under an hour, it was, that was clearly a mistake. Also, do not BCC. Here, the precautions taken by Reed and her team to ensure confidentiality of communications were careless, not reasonable. In all likelihood, by her own direction and or by recommendation of counsel, Reed has been BCCed on all email communications with opposing counsel since the outset of this lawsuit. You can't know that. That is pure speculation. In all likelihood, you don't know that because they should just be forwarded. As cautioned by the judge, this practice exacerbated, made worse the known and obvious risk of broadcasting privileged communications to opposing counsel. Plaintiffs do not suggest that Ms. Reed should be kept in the dark concerning developments in the case. However, the foreseeable risk, which occurred here, could have been easily avoided. For example, defense counsel could have simply forwarded the email communications with opposing counsel to Ms. Reed. They go on to quote MCLE Inc., managing client relationships. They're now quoting a training saying that when a lawyer includes the client on emails with opposing counsel, the client replies to all, and the other counsel sees the message, an argument could be made that the privilege is now waived for all purposes. Right. The argument is being made. Clearly. Under the circumstances here, including but not limited to the judge's warning to future litigants, this court should find that Reed waived any privilege with respect to the subject matter of the December 16th email. They go on to argue, even if Reed did not waive privilege, plaintiffs are entitled to use the subject email for impeachment purposes, saying even if this court determines that Reed's email communication was inadvertent and that she took such precautions sufficient to preserve privilege, the plaintiffs are entitled to retain and use subject communications to impeach Reed in the event she testifies or answers under oath inconsistent with the statements in the email. They go on to cite case law on that we are going to zoom because I do want to get to that other hearing and we're almost 3 hours into stream. They go on to argue that here, Reed's choice to respond to the entire email chain and to make factual assertions directly relevant to disputed issues in this case, whether inadvertent or not, is a bell that cannot be unrung. Consistent with the above rulings, the court should be permitted the plaintiff should be permitted to retain Reed's entire email and use at trial and further depose Reed concerning the purpose and meaning of the subject email communications with any conditions the court deemed necessary. So they want the court to say it's not privileged. And if the court says it's not privileged, then they want the court to say, or if the court says it's privileged, then they want the court to say you can use it for impeachment, even if it's privileged. Okay. That's from Attorney Diller. We've gone through the exhibit. We need to go to Reed's team's reply to the opposition. One more document. Let me go pull it up because I pulled up all the side questy ones. And now the side questy ones are what's everywhere. All right, let's get to the reply. We have a reply. We have an affidavit. We have much more to read. One more time. Reed's reply to that opposition. We have a full fucking fleet of documents today. Reply in support of defendant Karen Reed's motion for an order requiring plaintiffs to delete that shit. Hyperbole. Plaintiff's opposition relies on alleged practices by Reed's counsel, which plaintiffs make up out of whole cloth. They then argue that these non-existent practices resulted in a waiver of perhaps the most important privilege recognized by Massachusetts law, the attorney-client privilege. Plaintiffs do so in a cynical attempt to abuse a party's honest mistake and seek an illusory litigation advantage. And this specious tactic should not be condoned. Plaintiffs' alternative argument that they should somehow be allowed to keep defendants' inadvertently produced non-waived attorney-client privilege communication for impeachment purposes is equally baseless. On February 2nd, 2026, Reed served her answer to second interrogatory, and even a cursory comparison of the two documents, the answer and the privilege communications, demonstrates that the privilege communication does not provide plaintiff any additional areas for impeachment. So they're saying the email is the same, or at least is same enough that you can't use it for impeachment. Plaintiff's assertions are meritless, and the court should reject them. The next heading is that Reed's email resulted from an accidental reply all, the one time her counsel BCCed her on an email. Why would you BCC someone on an email one time? Okay, this is a bad idea. See what happens? Plaintiffs base their entire argument or their entire waiver argument on the allegation that by her own direction and or recommendation of counsel, Reed has been BCC'd on all email communications with opposing counsel since the outset of the lawsuit. Yeah, and I said, how the fuck could they know that? Reed's lawyers say factually, this is simply false, and nothing in the record supports it. In fact, Reed attaches to this reply an affidavit from Reed's counsel confirming that this was a one-time blind copy. Well, you'll never do that again. That's real bad luck. That's real bad luck. Blue Eyes Fairy said, how do you reply on a BCC? I don't know. I don't know. I really don't. But also, this is why we don't BCC. It goes on to say, factually, this is not true. Reed attaches an affidavit confirming that this happened one time. And it got fucked the one time it happened, didn't it? This is why you don't do it. You're never going to do this again. Never, ever. This lawyer will remember this forever. It goes on to say, however, even without this affidavit, there is nothing in the record that allows plaintiffs to make this unsupported logical leap regarding counsel's practice, nor do they point to anything in support. In the other cases, it says that this had happened numerous times, that this was not the first time that it had happened. And the court was saying, look, you've made this mistake more than once. You run the risk of now waiving privilege because you've made this mistake more than once. That's not the case here. Instead of seeking to capitalize on a common and understandable human error, which most lawyers, professionals, and other email users have committed at one time or another, plaintiffs and their counsel should heed Judge Fabricant's advice, which they conveniently replaced with ellipses in their opposition. As a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures. The inadvertently disclosed privileged communication provides plaintiffs no unique areas for impeachment. Reed recently served her answers to plaintiff's second interrogatory, which seeks the basis for her affirmative defense that the third parties caused Mr. O'Keefe's death. That answer is attached as Exhibit 1. Oh, good, we're going to go read it. Comparing this answer to the privileged communication demonstrates that there are no areas for impeachment unique to the privileged communication. Said differently, ergo, if plaintiffs intend to impeach Reed later, they can simply use the sworn answer. They don't need the privileged communication. So Reed's lawyers are saying, what we told you and what's in the email are the same. Same. To be clear, Reed has no problem with plaintiffs asking her about any of these topics. She only opposes their attempt to use sharp practice to strip her of the benefit of attorney-client privilege. Ergo, don't be a dick. And then they attached as Exhibit 1 the answer to the interrogatory. Answer to the interrogatory. Interrogatory number 2. State all facts forming the basis of your claim that plaintiff's damages arising from the death of John O'Keefe were, quote, caused by acts or omissions of third parties for whom Ms. Reed is not responsible. Answer. This answer is 3 pages long. Oh, you want the answer? Here's the answer. Answer. Ms. Reed objects to this interrogatory to the extent it seeks information outside of her knowledge and possession. Okay, but then you can't use it as a defense. Ms. Reed further objects to this interrogatory to the extent it seeks information subject to the attorney-client privilege or work product doctrine. Then you can't use it as your defense. Ms. Reed also objects to this interrogatory as premature because discovery is just beginning in this case, and she has not yet received full production from MSP, Norfolk DA's office, among others, which may contain additional evidence or information relevant to her answer. Fair. That's fair. Guilfoyle says, this is so petty. Yep. CEG, my statement about civil practice. I do not love it at all because it's important to them. But yes, it also feels petty. Reed is preserving objections. Therefore, Ms. Reed reserves the right to amend and supplement this answer as discovery proceeds. That's fair. Hey, Reed's team is saying we still don't know the full extent of what we don't know. We know what we know, and we know there's a lot we don't know, and we reserve the right to amend this as we learn more. So without waiving those objections, Reed answers. Preserving the objections is proper. I'm just talking back to each of the documents everybody files. Quote, I was acquitted by jury of all criminal charges relating to the death of John O'Keefe after a full and public trial that exposed pervasive investigative misconduct and corruption. I did not cause and am not responsible for Mr. O'Keefe's death. The other side is going to say, this is arguendo, chat. This is arguendo. The other side is going to say, the jury found that the DA's office did not prove beyond a reasonable doubt that you did it. That does not mean that on a civil standard, you are not responsible for it. Those are two different things. So, yes, the DA's office did not prove that this was a murder, which was a wild overcharge. But that does not mean that you were not responsible for his death. That is what their argument is going to be. However, we continue. She goes on to say, I did not strike Mr. O'Keefe with my car. Mr. O'Keefe's wounds are inconsistent with being hit by a vehicle. Don't disagree. and consistent with being in a physical altercation and attacked by a dog. They should just attach the transcript, right? Just attach the transcript. Here's what all the experts said at trial. Here's what the expert said. The credible evidence indicates that he was beaten inside the home at 34 Fairview in Canton, Massachusetts, but you need to cite to that evidence. I think it is fair to say, okay, but what evidence? The credible evidence indicates that he was beaten inside the home at 34 Fairview, Canton, Mass. On the night of January 28th, 29th and died as a result. Below, I describe certain information and facts of which I am currently aware. However, I believe there are additional facts and additional evidence that I do not possess, which will further support the referenced affirmative defense. Fair. To date, I've not engaged experts for a trial in this matter, and therefore this response does not take into consideration their opinions. I mean, because you can rely on the state's expert, Dr. Wolf, not hungry like the, who said John O'Keefe's injuries are consistent with hitting the back of his head. And there are varieties of ways that John O'Keefe could have fallen and hit the back of his head. So there are facts like that can be included in here saying, I did not cause the death. The argument on the other side is going to be, but if you saw him in the snow and left him out there, you might still be responsible in some way. There are going to be other arguments because the civil standard is different. But the trial has quite a lot of information in it that the jury relied on. Continuing. Wolf, hungry like the, not Dimples. That's correct, Rex88. I have forgotten my own nicknames. Wolf, like the animal. Yes, Wolf, hungry like the, not Dimples. Fair. Below, I describe certain information and facts which I am currently aware. There will be experts. Additionally, at trial, I will rely on my attorney's experts to explain the evidence, what it means, and how it indicates who was responsible for Mr. O'Keefe's death. Other than knowing I did not hit John with my vehicle, and it was not me who killed John O'Keefe, I am presenting my knowledge solely as a layperson who observed evidence obtained and presented in connection with 2 criminal trials against me. She's saying, I am not responsible for John O'Keefe's death because I did not hit John O'Keefe with my car. These are all the ways I did not hit John O'Keefe with my car. John O'Keefe went into the house. This is what she is going to say. John O'Keefe went into the house, and then when I saw him the next morning, he was dead on the lawn. I left, and I went home and connected to the Wi-Fi and then was calling his phone. So she goes on to say, during my criminal trials, multiple witnesses provided testimony supporting this affirmative defense. First, my counsel engaged a private investigator who took photographs of a cement-ridged curb just inside the garage, and the pathology expert my counsel engaged opined that Mr. O'Keefe's head wound came from a ridged ledge. Further, 3 separate doctors testified over the course of 2 criminal trials that Mr. O'Keefe's arm wounds were consistent with an animal attack, and my understanding is that the owners of the house at 34 Fairview, Canton, the Alberts, testified in the first criminal trial that the Alberts' dog, Chloe, never went into the front yard. Therefore, I believe Mr. O'Keefe was inside with Chloe. Those are the type of facts that they wanted to see in the interrogatory. This expert says this. This witness said this. The dog was not in the front yard. If the dog was not in the front yard, the injuries to the arm didn't happen in the front yard. If the injuries to the arm happened by a dog. Those things are the types of facts that they wanted in the first interrogatory responses. Next, Ian Whiffen, the Commonwealth's own witness, confirmed Mr. O'Keefe's Apple Health data showed 3 flights of stairs were climbed after 12:20 a.m. The Apple Health data also shows Mr. O'Keefe taking enough steps to get inside the house at 34 Fairview Road in Canton. Mr. Whiffen presented further evidence that Mr. O'Keefe's phone battery temperature stayed flat for 3 hours in the middle of the night at just under 50 degrees, which is too warm to have been outside in the snow, and then plummeted just before I found his body at 6 a.m. Therefore, the evidence supports the conclusion that Mr. O'Keefe was indoors before 6 a.m. I also understand that a stain on Mr. O'Keefe's sneaker had DNA from 5 male contributors. I understand that there were 5 males inside 34 Fairview Road in the early morning of January 29th, 2022, and that no one saw Mr. O'Keefe outside before 6 a.m., including Lucky Laughran and numerous others. In addition to these facts, the individuals inside the house at 34 Fairview in the early morning of January 29, 2022, also took actions that strongly suggest wrongdoing, including tampering with, destroying, fabricating, and manipulating evidence, all in a concerted effort, all in a concerted effort to direct blame towards me. At the same time, the individuals and entities who had the responsibility to fully investigate the circumstances of Mr. O'Keefe's death, including MSP, Canton PD, Norfolk DA's office, and their respective officers, troopers, and employees, failed to adhere to their duties and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house after Mr. O'Keefe's body was discovered. Like, how many butt dials are there really? Like, honestly, how many butt dials are there really? It goes on to say, they did so because of, among other things, personal connections between lead MSP investigator Michael Proctor and individuals within the house, Proctor's and other investigators' inherent bias, and the occupants' connections with various local, state, and federal law enforcement. The individuals in the house that night engaged in a concerted effort to direct the investigators' attention away from them and towards me instead. Additionally, based on the information and evidence available to me, I believe that one or more of the occupants of the house at 34 Fairview, during the early morning hours of January 29th, caused Mr. O'Keefe's death. However, as a result of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured, and I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. What I do know, without any doubt, is that I played no part in causing, participating in, or contributing to his death in any way. Signed, Karen Reed, February 1st, 2026. Okay. That, again, when they said, based on what, Karen Reed's like, this. Based on this. Blah. And when Karen Reed gets to trial on the civil case, this is what we are going to see. And the explanation is going to include, I wish I had more answers. I would also like to know what the fuck happened. But where are the phones? What are the butt dials? How does a butt answer? What the fuck was Brian Higgins doing at Canton PD? Drunk on fucking Jameson and whiskey? No, Jameson and ginger. And Emily, Jameson and what? Drunk on Jameson and whiskey and ginger, going to Canton PD, walking around, moving cars in the middle of a fucking blizzard at what time in the morning? Okay. So what the fuck was he doing? Trisha Lynn said, I thought he was the one drinking Crystal Light. No, that was Matt McCabe. Matt McCabe was the one drinking Crystal Light and vodka or whatever. Or at least to the best of my memory. Because we clowned it in trial 1 and we didn't get back to it in trial 2. So when this goes to trial, a lot of the trial is going to be the plaintiff saying you are responsible for John O'Keefe's death and Karen Reed saying no. The investigators didn't investigate. The people inside 34 Fairview never came clean in what happened in the house. And even if this was an accident and John O'Keefe slipped and fell on stairs because everybody was drunk, they all then covered it up and rendered no aid and put him out in the snow. He got in the snow somehow. And if the dog was never in the front yard, how did he get injuries to his arm? The evidence, Karen Reed is going to say, the evidence is going to show that John O'Keefe was not hit by a car. I did not hit him with a car. I left. What happened at 34 Fairview after I left? I do not know. I left. And I connected to the Wi-Fi. This is me connecting to the Wi-Fi. That's going to be the argument. And then it's going to shift onto the investigation. And the O'Keefes are going to be arguing, you caused his death. And Karen Reed is going to be arguing, no. Okay. So, with all of this background, yesterday there was a hearing regarding the email. Miguelina, will you do me a favor and just let the app know we are shifting to the hearing since we have been streaming for like 3 hours and 18 minutes, that we are shifting to the hearing from yesterday because we are going through 3 hearings today. We're just like getting it done, everybody. Getting it done. Thank you for sending the app notification. Let's shift back to court in Massachusetts from yesterday. Let me pull that up real quick. I have it. I have so many things in my notes.
Third at
All right, we're going to grab that and go to court. Hear ye, hear ye, hear ye. We have not hear ye. I mean, it's Zoom court. Hear ye doesn't feel quite right, but hear ye, hear ye, hear ye. Draw near and ye shall be heard. The law nerds are going back to court. Yay. For the argument over Karen Reed's emails. Email. Singular email. Is the email privileged? Can it be used for impeachment? What's going to happen with the email? Let's go to court. Some of you are asking what happens. I don't know. I didn't watch this hearing yet. I saw that it happened and I waited to watch it with y'all. So I don't know what the court's going to do. So we're going to have to watch it. We're all going to find out together. And if anybody's watched this hearing, if no spoilers, do not find yourself yeeted prior to the Corey Richins case starting. Don't get yeeted. Don't get yeeted with the spoilers. No yeet.
all versus CNC Hospitality LLC et al. Your Honor, we have the parties present by way of Zoom. We have Attorney Diller for the plaintiff. We have Attorney Beaton for defendant CNC. We have Attorney Tang and Attorney Bell and Attorney Seligson, Attorney Rosenberg and Attorney Jackson.
The attorneys keep moving.
Of Attorney Reed.
Thank you, court clerk.
Reed.
The clerk just said, did you hear that? The clerk just said for Attorney Reed. I also love that Jackson has basically turned whatever office he is in into like a podcast studio with the wood slats that everybody has started using for the backgrounds of podcast. We've gone full podcast studio. Hey, the lighting's good. The lighting's good. We don't have any backlight. We don't have any weird colored walls. It's easy to see. And Attorney Seligson, I think, is at the same firm of the stand desk because we're here for it. All right. Let's continue.
Attorney Seligson, Attorney Rosenberg, and Attorney Jackson present on behalf of Attorney Reed. Defendant Reed.
Good afternoon, counsel.
Good afternoon.
So, to Attorney Diller and Attorney Seligson, a couple of general points. I purposely did not ask for you to provide me with the email in question so I could have the benefit of argument without knowing its content.
That's very, very respectable, Your Honor. The judge is like, I did not want the email in question. The contents aren't the point. What happened is the point. That is very, very lawyerly of you, Your Honor. That is very judge of you. I appreciate it. Did you see my response, chat? Did you see my response? Give me the tea immediately. Right. This is why I am not the bench officer. I want to know everything.
However, to decide the issue of possible preclusion of any future use of the email for impeachment purposes, I think I will need to see the email. So I'll ask Attorney Seligson to provide to Clerk Donovan in a sealed envelope a copy of the email.
That's fine, Your Honor. We'll do that right away.
Okay, next, let's dispense with any back and forth on what the rules of professional conduct and claimed.
The judge is like, let's dispense with the fuckery. Because Diller, I don't think Reed's attorneys came out and said, you're being a dick. I think they maybe gave the illusion that it was unreasonable. But the response was, they're name calling me. They're name calling me. How dare they? And so I appreciate the court setting the ground rules of stop it. I don't want to hear the back and forth of who violated the rules or whatever. Can we just get to whether privilege was waived? I appreciate the court.
Impropriety on the part of Attorney Diller. Attorney Seligson, I think your one superior court decision.
The other parties don't need to be there. This is not relevant to the other defendants. This is really between Karen Reed's attorneys and Diller. And the other attorneys have a right to be there for the other parties and see what's happening, but it has nothing to do with them. This is specifically between plaintiff and defendant Reed versus all the other hearings that everyone was a part of. Also, I am not covering anyone. There is just a blank space and a wall here.
Constitute sufficient case law for an attorney to understand their obligations under these unique circumstances. And let's all agree that the circumstances here are unique, just like they were in the Charm case. We can all agree that
I love this, Judge. We can agree.
Inadvertent disclosures usually involve an attorney producing in discovery a document that should not have been sent out.
Fair.
In this case, the disclosure involves a client. And Attorney Diller, let's also be aware that I see no reason not to credit Attorney Seligson's affidavit about blind copying his client being.
We did not go through Seligson's affidavit, but it was contained in the body of the motion. Seligson's affidavit said this happened once. This was the first and only time this has ever happened. And the court is saying, I believe that.
One-time event. So
Terry also asked a great question in the chat. Terry said, unique, really? Accidental disclosures happen. Accidental disclosures do happen. They rarely end up in front of the court. It is unique that the attorneys are fighting over this. Normally, it is just handled between all the lawyers. Hey, this was clearly an error. Hey, not a problem. This normally doesn't, it is unique that it gets before the court because generally everybody understands that this can happen. You need to give grace and grace will be given back. So yeah, it is unique that the court has to get involved. Most lawyers work this out amongst themselves.
I see to be the questions here are, like Charm, whether Ms. Reed has shown that she and her counsel took reasonable steps to preserve the confidentiality of the communication, and two,
he's narrowing
even
down
if the answers to interrogatories in the inadvertently shared email don't provide plaintiffs any additional areas of impeachment, as suggested by Attorney Seligson, what if future sworn statements of Ms. Reed and the email do? So let's try and tailor your arguments accordingly. So Attorney Seligson.
I appreciate the way the court has narrowed down the question. I want you to address this and that. These are the two things. One, did attorney-client privilege get waived? Two, can that be used for impeachment if anything down the road that is said contradicts it? So, yeah, they shouldn't be in court on all of this. We're in a everything shouldn't have happened. None of this should have happened. But alas, here we are.
It's your motion, so I'll hear from you first.
Thank you, Your Honor. I appreciate the opportunity, and I think you synthesizing the issues really will cut to the chase.
He did it well. I think the judge did a good job with that.
You referenced the Charm case, Judge, and of all the cases that there are on inadvertent disclosure, and there are many in Massachusetts, and there are many around the country, the Charm case could not be more on point. Judge Fabricant faced the exact same issue.
It's probably the only case about a client inadvertent disclosure in Massachusetts, right?
That is correct, Your Honor. I was not able to find anything else where, as you said, it's normally the lawyer who includes something in a batch of documents.
Excuse me, Seligson. My guy, you and I are going to have issues. Excuse me. Judge M was previously the preferred and favorite beloved voice of the law nerds. And you're just rolling in here and the law nerds have fallen off of their fucking chairs. Sir, do not come in here charming the law nerds out of their seats. They have swooned. I can see it in the chat. Swooned. They have all swooned. Sir, I am trying to remain somewhat attentive to the issues that are happening here. And all of a sudden, everyone has just gone, oh, you have distracted the chat. You have distracted the chat. I saw it. It all just went, oh, hello, sir. Mr. Seligson, stop it. I'm teasing. Chat. All right, continue.
Or an outside service has included something in about your documents, and the lawyer on the other side of the case gets that inadvertent disclosure. Here you have, in the advent of digital communications, you have an attorney in charm emailing opposing counsel, copying his co-counsel, blind copying his client. The client gets the communication intending only to respond to his lawyer, writes back to everybody through a reply all. Judge Fabricant explains how that can happen to anybody. And what she does is she analyzes whether or not the lawyer and the client acted expeditiously. And she uses the word used maximum effort to recognize the error, address the error, try and reclaim the communication because it was not a voluntary disclosure.
It was noted very quickly. Also, I'm not surprised Seligson is arguing the motion. You break it, you bought it. This was your BCC. You break it, you bought it. You go explain it to everybody.
In that case, Judge Fabricant granted the motion to strike that email, agreed that there was no waiver because the lawyer, even though he had done that once before, he had blind copied his client and the client had replied all. And even though the lawyer in that case simply asked the receiving lawyer to delete, destroy, and not use the email, did nothing more. Months later, that email is attached to an exhibit, to a motion for summary judgment opposition, and suddenly the lawyer thinks he needs to move to strike. So the email really wasn't reclaimed in the same way we have done, in stark contrast to that case and those facts. I've sworn in an affidavit which you credit, Your Honor, and I appreciate that because it's sworn under oath, and I stand by it. This is a one-time event,
Hey, Your Honor, bro is never going to BCC anyone on anything ever again in the history of forever. Chat, can you imagine the phone calls to this attorney from other attorneys on the team and from Karen Reed when this was discussed? Can you imagine? I can imagine there was some internal disagreement after this had happened.
Time incident where Miss Reed was blind copied. Inadvertently, she replied to all, not intending for anyone but her counsel to get that reply. That squares with charm. Immediately, my colleague Aaron Rosenberg reached out to Mr. Diller. That was 39 minutes later. Recognized there was a reply to all, recognized there was an inadvertent disclosure, demanded that it be deleted, destroyed, and not used. Mr. Diller said no, or didn't respond. I then reached out 44 minutes later, confirming, delete it, confirm you've deleted, don't use it.
Listen to this. Listen to how this went down. We reached out and we're like, this is an accident. Delete it. Diller was like, nah, I am disinclined to acquiesce to your request. No, not going to do it. Not going to do it. Franz in the chat said, been following EB since coming across the Karen Reed case, and here I am from South Africa. Hello, law nerds. We have a number of South African law nerds in the chat. Hello. We can all talk about rugby a different day. Right now, we're curling. We're booping the snoot with curling. We'll get back to rugby a different day. But here we are.
recognized there was an inadvertent disclosure, demanded that it be deleted, destroyed, and not used. Mr. Diller said no, or didn't respond. I then reached out 44 minutes later, confirming, delete it, confirm you've deleted, don't use it, confirm you're not going to use it. Same thing, trying maximum effort to reclaim the privilege, to reclaim the inadvertent disclosure. We then had back and forth with Mr. Diller for a number of days.
Can you just describe for us all of the back and forth with Mr. Diller? I would like to understand the full thrust of the issue. Can you just explain all the back and forth? Because Mr. Diller's sitting there looking like he's looking up at the Seligson Square on Zoom with just no expression.
He refused to comply with us. We then served a motion. So we used the maximum effort. There was no pattern of behavior like this that you saw in Charm. There was maximum effort to reclaim it. So when you look at Judge Fabricant's analysis of the efforts by the client and her counsel, that we've done even more than Judge Fabricant allowed in granting the motion to strike. This is, by Attorney Diller, an opportunity which is evidenced in his opposition to our motion, Your Honor, where he actually goes so far as to make a sweeping allegation that he says that Ms. Reed and her team, in all likelihood, by her direction and or recommendation of counsel, has been blind copied on all email communications with opposing counsel since the outset of the lawsuit.
Yeah, I commented on that in the briefs. Look, here's my vibe on this. Vibes, I think Karen Reed, based on everything we've seen, all the interviews we've seen, I think Karen Reed wants to know everything that's going on in the case. Sure, fair. There's a lot of ways attorneys can keep their client in the loop without a BCC. I think that assuming, because Karen Reed has said that she has been incredibly involved in her cases, you can't assume that that means she's been BCC'd on every email, or this probably would have happened sooner, or during the criminal case, and we've never heard of it before. It is probably just forwarded, but you can't assume because she wants to be involved, and I agree, she has said in her interviews that she was reading everything they have. Fine. But it doesn't necessarily follow that she was BCC'd on everything and that they weren't taking reasonable steps to keep privileged communications privileged. You can't just jump to that conclusion.
Or recommendation of counsel has been blind copied on all email communications with opposing counsel since the outset of the lawsuit. That is an outrageously inaccurate statement. It doesn't even comply with Rule 11, where a lawyer signs his name to pleadings and certifies that he has a good faith basis to make such a claim. What that means is Mr. Diller is trying to take facts that don't exist, create this narrative of recklessness, which does not exist. Ms. Reed was blind copied once, replied all once, and trying to fit that squarely in to get around what Judge Fabricant says in her opinion, which is lawyers should not take the opportunity to use something like this as an inadvertent disclosure and take advantage of that. Your Honor, for the same reasons in Charm, you should rule that there was no waiver of the attorney-client privilege here. This was not a voluntary waiver. This was an inadvertent disclosure. This fits squarely with Charm. We've done more than the lawyer in Charm did. We've acted faster than the lawyer in Charm did. We've proven there was no pattern like there was in Charm. And Judge Fabricant still understood the importance of the most sacred of privileges, the attorney-client privilege, and did not allow those facts to erode it. And we asked you to reach the same conclusion, Your Honor. Regarding the impeachment value of this email, we'll provide you the email in camera as you have ordered, and you will see that it squarely fits with everything Ms. Reed has answered in the second interrogatory that was posed to her. So it has no impeachment value. The plaintiff's attorney was asked to return it. There's plenty of discussion in the rules of professional responsibility, in the case law about returning an email that's been inadvertently disclosed. Judge Fabricant speaks about, to quote her, she says, as a matter of courtesy and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosure. It's just, this should just end today. Mr. Diller should not be permitted to use it. He should not be permitted to disseminate it, and it should be destroyed. We've done everything we can to reclaim it, and I rest on those cases, Your Honor.
So you argued in your papers, and you just argued now about impeachment relative to the answer to interrogatory.
Yes.
And the email. But what about in the future, if there was some statement under oath by your client?
Your Honor, there will not be a statement under oath that the email can be used for impeachment purposes. Mr. Diller
we hope not, because we're all, as lawyers, tell our clients that they can't commit perjury, but
what Seligson is saying is that, Your Honor, what's in the email is same with what's in the interrogatory. And if Karen Reed was to say something different than what's in the interrogatory, she could be impeached with the interrogatory answer, not the email, because they are same. That's what Seligson's arguing. And the court is saying, but what if she says something different? And he's saying, look, the interrogatory and the email are the same. And once you see the email, because the court has not read it yet, once you see the email, you will see that if she says something different, the interrogatory answer can be used to impeach. You don't need the email. Does that make sense? Hopefully.
not all our clients listen to us all the time. At least my clients didn't always listen to me.
True.
So just the possibility of that in the future.
I understand, but I think that answer will be very clear for Your Honor once you see what is in the email and you compare it with what is in the interrogatory answers. I have to tread lightly because I don't want to say anything about the email, but you will see that once you read the email and you compare it with the interrogatory answers, if there was something inconsistent with the interrogatory answers, then sure, then Mr. Diller can use that for impeachment purposes. But the email itself has no impeachment value once you look at it with the interrogatory answer. There have been 2 interrogatories served on Ms. Reed. The second one asks her, and we suggested that to Mr. Diller because we were going back and forth about whether or not her first interrogatory answer he thought was needed clarification or expansion. So we suggested to him, ask another interrogatory about stating the basis for the affirmative defense in the answer to the complaint, which states somebody else was responsible for the death of John O'Keefe. In response to that interrogatory answer, we have, with Ms. Reed, assisted her, and she has signed her interrogatory answer that is consistent with what's in that email. So there's no impeachment value. He can use the interrogatory answers. What we're trying to avoid is him making the argument that somehow she has waived the privilege and he can use the email. There's no basis for it. And I think the in-camera review will answer that question squarely for you, Judge.
Okay, thank you. Attorney Diller?
Your Honor, thank you. I want to address first and foremost what was just raised, which is the reply brief. I think it's noteworthy that
it just, the slowness of the speech sucks the air out of the room, sir. It really does. It really just sucks the air right out of the room. Just
counsel for the defense did not file this motion under seal. In fact, they attached a reply brief that says verbatim, comparing this answer to the privilege communication demonstrates that.
Are you going to argue that they've disclosed what's in the email, therefore in their reply brief they waived the privilege of the email, therefore this is moot? No. Is that what you're going to argue?
Counsel for the defense did not file this motion under seal. In fact, they attached a reply brief that says verbatim, comparing this answer to the privileged communication demonstrates that there are no areas for impeachment unique to the privileged communication. And then they add as an attachment to that email the answer to interrogatory.
No, not the email.
Under oath statement
reply.
signed by Karen Reed. All of which, given what's happened in this case, has been picked up in the news and become part of the public domain.
Y'all, I got to be honest. Please let me know if you've seen it. Did you see the response from the reply brief picked up by the news and like everywhere? Because honestly, I have been looking for news that is not news about Nancy Guthrie, and I can't even find Olympic results at this point. I honestly can't find any other coverage to the point that it's beginning to piss me off, honestly. I've seen nothing about this at all. Also, the things Karen Reed said in that reply are basically what she has said in the interviews that went before. It's not, you guys, was anything in that interrogatory reply anything different than what you've seen her attorneys arguing and pointing to in the interviews that they've given and during trial? Maybe I haven't heard them specifically say, Albert said Chloe wasn't in the yard, but maybe because I forgot. It's just, it's all stuff we heard at trial. A few of you had said the shoe DNA has been in the news. Fair, but we heard that in trial. Maybe we were paying attention. Maybe people just weren't paying attention. Because we've heard it. But Diller is like, tell me how, Your Honor, the news has picked it up as part of your argument.
The law's privilege is waived when its contents become.
Let me back this up a little bit. All right. He is going to make the argument I thought he was going to make. Well, good. At least I haven't lost the ability to kind of see exactly where these arguments are going. He's going to make the argument I thought he was going to make. But Your Honor, once the contents of the privileged communication have been made public, there's no more privilege. There it is.
Interrogatory under oath statement signed by Karen Reed. All of which, given what's happened in this case, has been picked up in the news and become part of the public domain. The law's privilege is waived when its contents become public. Counsel, to the extent that there may have been a privileged communication in the email to which I did not disseminate.
Jackson, your face is facing.
Chose to put its contents directly into a public filing and attach the answer to interrogatory to which Attorney Sellison just communicated to you stands for the same issues and the same facts are aligned. Now, I appreciate that Your Honor wants to look at this in camera. I would
Jackson's
say
face
to
is
you
facing
that
into HD. Well,
I'm not really sure.
He's got the best Zoom lighting setup you're gonna have. Like the lighting setup is it's gone beyond office and into you can use it as a studio. Fair. But the face is in HD of come on, bro.
Why we are here at this point, given that I understand why it was served. I did not disseminate it based on an agreement that I had with them, but I did point out case law why I believed that I could use it to impeach credibility, given that there were other statements that I believed to be inconsistent with that. And then I understand after I served my opposition, why then it would be filed. But I didn't understand why there was no attempt by counsel to seek an in-seal filing.
Because they want the answer to the interrogatory in the public, counsel. That's why. Because I imagine there was probably speculation about what was in Karen Reed's email, and they wanted to quell that speculation. That would be my guess if I had to guess.
Of this, together with the answer to interrogatory and/or an in-camera on all of it. I feel as if in Judge Fabricant's 2010 order, she's very clear that she says, a client who seeks to preserve the privilege has the responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and avoid practices that exact those risks. And then Fabricant gives a public warning to the bar in general. Says others should take note. Reply all is risky, so is BCC. Further carelessness may compel a finding of waiver of privilege. That was 16 years ago. The world and technology has advanced. We have all become more sophisticated with way to deal with it. We were also relying on an MCLE, which was written by a gentleman who was...
Sir, an MCLE training is not binding authority on literally anyone.
With the BBO that says an argument could be made that privilege is now waived when a client replies all to something that they were copied on. That just deals with the first issue, which I think the whole thing has been waived regardless of how you interpret Fabricant's decision. But the second issue, as it relates to impeachment, we have the late, great Judge Gantz, who wrote an opinion. We have Justice Kaplan, who both issued opinions. Both suggest you can't unring the bell. I identified that there were inconsistent statements in the email that was provided to me before anybody tried to recall it or advise me that that was intended as a client confidential communication. I then said, I'm not intending to disseminate it, but I do believe in arguments made that she's waived it, and I more so think it's significant that should she give inconsistent testimony moving forward, it certainly has impeachment value, which has been borne out by Justice Gantz, Justice Kaplan, Superior Court decisions that talk about the impeachment value of it. So ultimately, I stand by the position that, for starters, I believe that they have waived the any privilege that may have existed in the communication by publicly disseminating the contents of it. And then secondarily, I have every right to use it for impeachment purposes as we move forward in this litigation.
He might have the right to use it for impeachment. It doesn't waive it being privileged,
Your Honor,
though.
I rest on the papers as it relates, or will answer any questions that Your Honor has.
Your Honor, may I respond?
Sure, go right ahead.
It's your motion.
Your
You
Honor,
get the last word.
The notion that a litigant would
He is so mad. He is so mad. He is so mad.
be served with an interrogatory, answer the interrogatory under oath, and then somehow be deemed to have waived the privilege is preposterous. What I am arguing is, for impeachment value, there is none. And once you are able to see the email and compare it with the interrogatory answer, you will make that decision for yourself. I am confident. But if Mr. Diller served us with a motion and we served him with a motion and he attached signed interrogatory answers, or we attached signed interrogatory answers that had been served in the normal course, there's no waiver of the privilege. That's just not a valid argument. Secondly, Mr. Diller cites two cases in his brief, which is referenced today. Those cases actually stand for the proposition that there has been no waiver. The cases that he cites to, the Mirror Inc. versus O'Brien, the court found that Judge Gantz found that there was no waiver of the attorney-client privilege with an inadvertent disclosure. The case that he cites to in his brief, and he mentions as well, this is Judge Kaplan, Vigor Works versus Scansa. Judge Kaplan finds there was no waiver. Your Honor, again, this is desperation. It's an inadvertent disclosure. We've done everything we can to prove to the court under the reasonableness standard that Judge Fabricant lays out in Charm. It's the same fact pattern, same conclusion should be reached.
It's a very similar fact
Ask your
pattern.
court to allow the motion that the privilege has not been waived in part or in whole whatsoever, and that Mr. Diller, his clients, and anyone else who has had a look at that email be ordered not to be able to use it. Thank you, Judge.
Okay, thank you. I'll take the matter under advisement.
Okay.
Thank you,
Well,
Honor.
that's the end of that.
Thank you all. This matter is under advisement. This matter has a next date of March 5th, 2026 at 3 p.m. for the Rule 16 conference. Thank you all.
All right. It looks like they are done. Well, let's try to recap that as best we can. Let me turn this off so that we don't accidentally autoplay whatever comes next. All right. Let's try to recap what happened in this hearing, because ultimately the judge took it under advisement. What we saw in the arguments over Karen Reed's email was the attorney for plaintiffs, the O'Keefes, saying, look, Your Honor, first, it's not privileged. This isn't inadvertent. They weren't being careful. We should be able to use it for impeachment. But Karen Reed's attorneys filed a reply with her answer to the interrogatory, not under seal. So it's now all out in the public. So they've waived the privilege by putting the subject matter of the privileged communication out into the public. So it's not privileged anymore. To which Karen Reed's civil attorney Seligson responded, bro, what? That's just my summary, saying this was an inadvertent error. It does not waive privilege, and it should not be used for impeachment. And the court might split this issue. The court might split the issue and say it is a privileged communication. However, to the extent it differs from anything else Karen Reed said, it might become something that can be used for impeachment down the road. But the court has not evaluated the email. He said that at the beginning of the hearing and indicated at the beginning of the hearing that he wanted to hear their arguments on what the law was in this area before he looked at the email and decided. So the court took it under advisement. The court will issue a written ruling at some point in the future. We don't have that yet. We've only time traveled as much as we can. We've run out of room to time travel. But it's really hard to put the shit back in the horse and unring that bell. If the court finds that the areas are the same, the court might say, you know what? You can use the interrogatory. You can't use the email. They're same. You can't use it for impeachment. Delete the email. Or the court might say, sure, you can use the email for impeachment. However, it's same as the interrogatory. So what would be the purpose? So we'll see. I am very curious to see what the judge does. I do not think the judge will find that Karen Reed, through a reply all on a BCC from her lawyer, will find that she waived privilege. I just don't think that the court will determine that. And I don't think the vibes between the lawyers are going to get any better. Lisser in the chat said, what does that mean, use for impeachment? I appreciate that you asked the question, so I can back up just a little bit. When I say the court may find that the attorneys can use it for impeachment, it means that if Karen Reed says something under oath that contradicts what's in the email, They can use the email to say, okay, but you're saying A now, but in this email you said B. Is it A or is it B? And what Karen Reed's attorneys are saying is that the email is B1 and the answer to the interrogatory is B2. They're exactly the same content, just in a different format. So you can't use B1 to impeach. You can use B2 because same. So they shouldn't get to use the email at all. And that Karen Reed's attorneys are saying they went above and beyond to note the error and to fix the error. And the other side was just like, so the other side just doesn't want to adhere. And the court is like, everybody, stop it. Stop it now. Stop it right now. What are we doing with this email? I do not think the court will find that privilege has been waived. I will be interested to see if the court says that the other side can use it. However, live by the sword, die by the sword. You better hope that in the extensive litigation that is left to come, this doesn't come back to bite you in the ass, because lawyers will not forget, they will be petty, and they will make you eat it. So if you need anything from these lawyers, you're going to get a whole bunch of, sorry, we can't help you. Wouldn't that be nice? Too bad. Too bad. Newman in the chat said, which trial is the email being used in if the civil case goes to trial? That's what they are asking about it. But it can also come up in deposition. It's not just trial. Karen has not been deposed yet. So it could come up in deposition, and that's where it would come up sooner, is if she says something that's contradictory in deposition. So we'll see. It's just, you really don't, this is not off to a good start. This is not off to a good start with these attorneys. They are not going to work collaboratively. It seems things are not going to go well. Things are not going to go well. All right. There is one more thing that we need to talk about today. Emily, really? Yes. 4 hours of streaming later. Yes, there is another thing that we need to talk about today. Because there was a motion filed yesterday that I grabbed off of social media in one of the criminal cases relating back to the Proctor problems. So as we followed through in time, we have to get to the Proctor problems of it all. So forgive me that it looks awful. Getting the civil docket in Massachusetts is so much easier than getting the criminal docket. And in all of the things we were doing today, and the things that I was doing this morning, I did not have a chance to go find a prettier version of this document. But I figured it was the contents of the document that mattered the most, not how pretty it may or may not be. So thank you all. I'm glad we have it. Anyway, we do. Where did I put it? It is here. All right. We are going to take a look at a response regarding the Proctor problems we talked about in the criminal cases that we have talked about. So we're jumping into a different stream of thought, because a lot of the Proctor problems have been coming up in the Miles King cases. And I say cases because there is a group of criminal cases that are going forward that have the Proctor problems. And we have watched some of the hearings in those cases because they put Lally on the stand. They put Lally on the stand to ask him about why he hadn't turned stuff over. And he's like, I asked him for it and he never gave it to me. And I just, Oh boy. So if any of you have seen this was filed yesterday. I have not gone over it yet, other than saving it and then saving it for the law nerds, because I do enjoy discovering things in real time with all of you. Also, it was a very late night for EDB yesterday doing all of the things. So we're getting ready for trial, y'all. So it has been the vast focus of my attention of trying to get ready to make sure that we are ready for the Corey Richins case, which keeps throwing hearings up onto the docket. And I don't even know if we're going to get to see any of those, because they keep popping up into the docket. So let us zoom into the conversation around Proctor's phone that I saw yesterday. It seems to be filed stamped. This looks like it's filed stamped February 13th. I did not see it until yesterday. So Karen Reed's attorneys, there is probably another one, but Karen Reed's attorneys are filing in the criminal cases about Proctor's phone. All right? Okay. So that's what we are taking a look at now. This is the discovery issues going on with all of the different cases. King, Sinchero, De Los Santos, and Johnson. These are all cases where Proctor was the lead investigator. These are all cases where the Proctor phone problems are getting fought over. Response in support of Commonwealth's motion to provide, pursuant to a civil subpoena, information derived from former state police trooper Proctor's personal phone previously obtained through court order. Michael Proctor lacks standing to object to the Commonwealth's agreement to produce documents currently in its possession, Commonwealth, in response to a civil subpoena, despite his desire to hide his apparently appalling conversations with fellow law enforcement officers and others. I can see why I got asked to pull this up. Because Proctor's objecting? I'll go find that and I'll share it in the app. I'll share it with y'all. Oh, from what we've seen in just the protective orders, it indicates that they are in fact horrific. So Proctor's objecting and the Reed team is objecting to Proctor objecting. None of this would be happening if Proctor hadn't lost his phone. Despite his desire to hide his apparently appalling conversations with fellow law enforcement officers and others, which he clearly assumed would remain permanently shrouded in the secrecy of his group chats. Dude, nothing's secret in a group chat. Cases are cited saying, holding that even a party to a case, which Proctor is not here, does not have standing to object to a subpoena to a third party unless it raises a colorable privilege or privacy issue. And so they are citing case law saying Proctor does not have standing to say to the DA, do not give them that information. This is between the district attorney's office, Reed's attorneys, and all these defense attorneys. Stay out of it, Proctor. This is not your fight. You don't get to intercede, is what they're arguing. And Proctor's like, excuse me, it's my shit. As referenced in the Commonwealth's motion, I'm going to have to go find all of these. We might have to do this. We might have to do a subsequent day where we do a deeper dive into all of this. As referenced in the Commonwealth's motion, both the family of John O'Keefe and Karen Reed served subpoenas on the Norfolk District Attorney's Office in the ongoing civil case between them. The Norfolk District Attorney's Office and the parties to that civil case negotiated and executed a confidentiality agreement whereby the DA's office would provide certain previously identified documents concerning Proctor's potential biases. Proctor filed an opposition to the Commonwealth's motion for permission to comply with the agreement, to which Proctor is not a party. The Commonwealth's motion should be allowed because so they're going to the criminal court, saying to the criminal court, hey, we're going to be turning over this stuff to this civil case. This is unusual. But you gave Proctor back his phone and Proctor fucking yeeted it. Lost it. I'm using lost and yeeted synonymously. Miraculously lost the new iPhone. I have pressed X to doubt. Where is it?
Survey says.
The Norfolk District Attorney's Office and the parties to the civil case negotiated a confidentiality agreement. The Commonwealth made a motion for permission to comply with the agreement. Proctor's not a party to the agreement. Commonwealth's motion should be allowed. It sounds like Proctor objected because 1, the O'Keefes and the Reeds are not, quote, fishing for information. 2, because Proctor's counsel has already reviewed the documents at issue and removed any that were privileged. And 3, because Proctor cannot use his own spoliation of evidence. Ding, ding, ding. You don't get to benefit from your, dirty deeds done dirt cheap. You don't get to benefit from losing your information that was under a preservation order. Luckily, someone else has it. So that someone else can now give it to the parties. Proctor cannot use his own spoliation of evidence and violations of other individuals' privacy rights to deprive the O'Keefes and Reed of the information that is potentially relevant to their case. The documents that are subject to the Commonwealth's motion were uncovered, as the Commonwealth explains in its motion, when the court ordered Proctor to provide to the Commonwealth his personal cell phone, which he has used since 2024. When the Commonwealth extracted data from the phone, it recovered what it referenced as text chats that contained voluminous information that the Commonwealth determined may demonstrate potential bias. The discovery was contrary to Proctor's prior counsel explanation. Oh, Emily, you talked about all of this earlier today. My memory was correct. Look, it's all in the... I should have just read this first. Fuck. Well, if we do it over again, I'll start with this, because their explanation is much more succinct than my and then. Either way, the discovery was contrary to Proctor's prior counsel's explanation to the court that the phone was unlikely to contain any substantive data. And then, as the court knows based on its prior orders concerning these documents, Reed's counsel has told Proctor's counsel many times, and as the Commonwealth's motion confirms, neither Reed nor the O'Keefes have ever received these messages. They are completely separate from the text messages Reed's criminal defense team and the Commonwealth received during the criminal trials. Right, because those were from the feds.
The FBI!
From a different phone. This is a different group of information. Right. Not the same. These are completely separate text messages from the ones Reed's criminal defense team and the Commonwealth received during the criminal trials, which Reed has now produced to the O'Keefes. Different. More. Specifically, Reed understands from the Commonwealth that the messages in question were recovered from a messaging application, not the phone's text messaging records. The Commonwealth, which prosecuted Reed twice for murder and is clearly not biased in her favor, determined that the particular documents it intends to produce go to Proctor's bias and have not been previously disclosed. Oh my God.
Mention it all. Mention it all.
These are not the makings of a fishing expedition. This is simply an attempt by the Commonwealth to produce specific curated documents on a particular topic to two parties on opposite sides of a pending civil case in order to comply with its obligation in response to duly served subpoenas. In fact, through compliance with this court's orders, the Commonwealth has already made a determination that these specially selected documents are relevant to criminal investigations Proctor ran, which includes Reed's prosecution. They are therefore obviously relevant in the civil litigation that relates to the very investigation and prosecution, because the defense, this is my addendum, because the defense of Karen Reed in the civil case is, I did not kill John O'Keefe, and I wish we had more answers about how John O'Keefe was killed, but we don't because this investigation. So documents that go to this investigation are relevant to her defense. Correct. Yup. Mm-hmm. Mm-hmm. They go on to say the documents in question are also not privileged. Pursuant to the court's previous orders, Proctor's prior counsel had an opportunity to review and remove from documents anything he asserted were subject to the attorney-client or material privilege before any production took place. Such documents will also not be produced to the O'Keefes or Reed. Finally, Proctor makes two cynical and meritless arguments. Oh, they're loving that. They're loving that. They've used that in a couple different motions at this point. Finally, Proctor makes two cynical and meritless arguments. First, he writes in his opposition that, quote, if the Reed attorneys want discovery from Proctor, then serving a request for production of documents on Proctor is the unrelated federal matter constitutes the proper vehicle in which to obtain such discovery, rather than having this criminal court amend its protective orders. Oh, boo-boo, no. No. That's not how that works, Proctor lawyer. That's not how that works. They're not the same set. They're not the same discovery. It's fuck. They go on to say this disingenuous argument ignores the fact that the same counsel that filed Proctor's opposition has informed Reed's counsel that in the short period of time when the Commonwealth returned his phone in question to Proctor and when Proctor engaged his current counsel, Proctor lost the phone and no longer has access to it. Therefore, as Proctor well knows, the O'Keefes and Reed can only obtain the potentially relevant documents from the Commonwealth. And Proctor should not be permitted to blatantly rely on his own spoliation of evidence to keep his biased and offensive speech shrouded in secrecy. Ergo, give us the shit. It is full mention it all, receipts, timeline, screenshots. Like, Proctor, how are we losing the second phone? You get a new phone and you're just like, there's nothing on the new phone. They find everything on the new phone. And now the new phone is like, poof, poof, poof. And we have an idea of what's on this phone, don't we? Yeah, we do. Yeah, we do. Poof. We're just
that's suspicious.
All of it.
That's weird.
The entire soundboard applies to this shit. Can you imagine how fucking mad? I know how mad I am. I'm not one of the lawyers involved in this case. And I know how pissed off I am. Because can you imagine being on the phone call saying, hey, so the DA's office said we need to subpoena you, so we're just going to subpoena you guys for the phone. Oh, my client's phone? So funny about that. Yeah, he lost it. So, you can't subpoena the phone because we don't have it. Sorry. What do you mean? What the fuck do you mean you lost it? What do you mean you lost it? We need to add this. We're going to need to add this to the soundboard. Hold on. I hope this is the correct. Emily, what are we doing? What are we doing? We're going for it. We're just going for it. We're going for it because I'm not quite sure which music they're using in this, but we're going for it because we might need to add this to the soundboard too. Because
do people just quit without getting to 10? Because I watched the show, but like on TikTok.
Where is our what do you mean?
I'm like, that's a good wing. This one is warm.
It's starting to move up a little bit.
That one wasn't that bad, Chris. I think you.
We're going to need the what do you mean?
Ooh, yeah. She's warm.
She is warm.
I was kind of in my head at the beginning. I was like, is this show real?
Right, no, I get that.
And I don't think that anymore. Oh my God.
I know.
This is the lawyer. This is the range of emotions from the lawyer on the other side of the phone as Proctor's counsel is trying to explain that Proctor's phone is lost. This is the trajectory of the reaction. This is the stages of what do you mean? This is Karen Reed's counsel on the phone going step by step into what do you mean?
I don't know what to, nothing helps.
I know.
I feel like I'm gonna die.
I know.
Uh-huh. This is the reaction.
Have you ever had anybody act like this?
This is it. This is the lawyer on the other side of the phone.
No, I get it. I get it.
This went bad? What do you mean? What do you mean by shaking it? What are you doing? What do you mean? What do you mean? What do you mean?
That's that. What do you mean? What do you mean? That is the entire range of emotions of the lawyer on the other end of the phone trying to process Proctor's phone is lost. We might have to add, what do you mean, to the soundboard because A, Hot Ones is fantastic, and B,
Have you ever had anybody act like this?
Yeah.
I've never seen anyone act like this, by the way. J Law, I've never seen a case like this. I've never seen a defendant act like this. I've never seen anything fucking like this. I have not. I have not seen anything like this. And yet here we are. Here we are. Here we are.
I get it.
This went bad? What do you mean? What do you mean by shaking it? What are you doing? What do you mean? What do you mean? What do you mean?
That's how I feel. That's how I feel. That's how I feel these lawyers were responding to Proctor's lawyer saying, so about that phone, yeah, we don't have it. How do you do anything but buffer and just turn into what do you mean? You can't. You're just stuck with what do you mean? I think Jen in the chat said, have people not seen this before? Oh no, I think people have not seen this before. I think we've brought a new meme. It's worth it. It's worth it. Even if we get demonetized for using a clip from Hot Ones, it's still worth it. This is why we have sponsors. Why do we have sponsors, Emily? Because sometimes the meme is worth it. And this meme is 100% worth it. It's worth it. What do you mean? What do you mean you lost your phone? What do you mean? What do you mean? What do you mean? So they go on to say, as Proctor well knows, the O'Keefes and Reed can only obtain these potentially relevant documents from the Commonwealth. Proctor should not be permitted to blatantly rely on his own spoliation of evidence to keep his biased and offensive speech shrouded in secrecy. The interests, damn, I buffered. The interests of justice are not served by rewarding obstructionist, dishonest, and unlawful behavior by an individual previously entrusted with the immense power of the investigating homicides on behalf of the state of Massachusetts. Yeah. That. For justice. Second, they didn't hold back in this motion. Second, Proctor attempts to grotesquely leverage the fact that his own messages on his own phone contain explicit images of women that did not consent and are unaware of their photographs being shared. This is what we heard in the Commonwealth's. We went through the Commonwealth's protective order. I don't remember when we went through it. We'll link it down below because we went through the Commonwealth's protective order on this, indicating that there were photos on the phone and indicating that there were explicit images in some of these group texts. A lot of you were like, I didn't remember that. It was in the protective order that there were explicit images that were not being sent by the individual whose images they were of. This is going to spawn a whole bunch, or should spawn a whole bunch of separate lawsuits. This should spawn a whole bunch of separate lawsuits. But Proctor attempts, they say, to grotesquely leverage the fact that his own messages on his own phone contain explicit images of women that did not consent and are unaware of their photographs being shared. After apparently violating their constitutional and legal rights by privately obtaining, keeping, and using these images for his own and his friends' personal predilections. Ooh, that's a strong. That's strong. Proctor attempts to nobly set forth in his opposition his abiding concern about these women's privacy rights. Dude, bro, that ship has fucking sailed. And fuck you for that. Honestly. Emily, you're not. We have completely gone beyond objectivity for me with Proctor. The objectivity is no longer in the room with us. I have tried to hold on for one more day. I'm done. The lost phone. And then arguing that the group text with your friends have explicit images of people who did not consent to those explicit images, and therefore it shouldn't be given to people? Nah. Nope. No. Absolutely not. So I hope that there is a process that those who might be in the photographs are able to find out if they are, so that they can leverage their own lawsuits, among other investigations that I hope are ongoing, because there should be. So Proctor setting forth his concern about the privacy rights. If you were concerned about privacy rights, the photos wouldn't be in your fucking group texts. You know what you're going to find in my group text? That meme, by the way, will be in there. You know what there aren't? Any explicit images of anyone. It's really not fucking hard. It's just not. It's just not hard. It's not. Protect the privacy rights by not putting it in a group text. It's really not too much to ask. Get sued. Honestly, it's appalling. I think the county of LA spent millions and millions in the lawsuit fallout from the photos shared of the Kobe Bryant helicopter crash. Millions. Okay. I'm going to try to read the rest of this motion. But it's just there's no words for how awful. It's awful. But also, what else is there? And after the lost phone, oh, you think it's all going to go away? It's not going away. It's not going away. It's not going to go away. And it shouldn't. The Lawnards will not forget. And henceforth, when people get flamed by their own messages, it's going to be called getting proctored. And generations from now, somebody's going to be like, why do they call it getting proctored? And I hope that whatever algorithm still exists shows them this. This is why. You are going to go down in the annals of history, and people are going to be like, why is it called getting proctored? I don't understand. What does that have to do with this? And then maybe one day, Poot will be standing in court comparing you to Aaron Burr, because we know how strongly he feels about that gentleman. So here we go. Second attempt. I know, we're going to stop calling it own goal. We're going to start calling it just proctored. You lost that for yourself. You just got fully proctored there, didn't you? All right. After apparently violating the constitutional and legal rights by privately obtaining, keeping, and using images for his own and his friends' quote-unquote predilections, Proctor attempts to nobly set forth in his opposition his abiding concern about these women's privacy rights. He argues that the court should prohibit the Commonwealth from producing his otherwise discoverable communications in which he long ago abused women's images to protect those same women. The irony should not be lost on the court. Proctor should not be permitted to rely on his own inappropriate and potentially illegal act of sharing other people's intimate photographs to prevent discovery of that very act, among others. Nor should he be allowed to hide his private act, his bad acts, based on his apparent newfound respect for third parties' expectation of privacy. Footnote 1. Oh, it's cut off. I don't have footnote 1. Sorry, y'all. Well, chat, unfortunately, we have meetings today, and I've streamed for a very long time. I apologize. We have some things we need to fix before trial. We are going to do a few questions. But for those of you that are like, Emily, what the fuck is even happening? What do you mean? What do you mean? What do you mean? Proctor is objecting to the Commonwealth turning over the discovery they have from the lost phone to Karen Read and the O'Keefes. That discovery fight is being had in the context of the criminal cases where this was all unearthed. The things that are so interconnected about this is unusual because the defense in Karen Read's civil case is but investigation. I am not responsible for John O'Keefe's death. Therefore, I am not responsible for all of this, but investigation. So, when we see motions from different things, they are all connected back to trying to get the additional discovery from Proctor's phone that the Commonwealth has in its possession, not the discovery that was turned over in the criminal case. Yes, there are protective orders for all of this. We will see what the court does, because I'm going to be keeping an eye on that. I'm also going to be keeping an eye out for Proctor's opposition. I think what I would like to do, chat, let me know if this works for you. When we're able to get back to all of this, I would like to go through all the motions in this order of motion, because we've seen Karen Read's response. We have not gone through Proctor's opposition. We have not gone through the Commonwealth's initial motion. No, we did go through the Commonwealth's initial motion. So I think we are missing Proctor's opposition, and we will pull that into other coverage when we have time. Does that work for y'all? So we have covered much today. We are waiting for the court to, in the civil case, decide what's going to happen with the Karen Read oopsie email. Don't reply to all. And we are going to wait to see what the court does with the Proctor problems from the lost phone. Those are the two things I am keeping an eye on as the civil case moves forward and as the fallout from Proctor continues in 4 other criminal cases, none of which have gone to trial yet. So if you want to stay in the loop, Lawnard app. If you are bummed that by the time you got to the Lawnard shop today and things were sold out, Lawnard app. The app knew about the launch before we went on stream, which is how things sold out before stream began, because the app knew first. So if you would like to stay in the loop, or if you're just preparing for the other KR trial with Corey Richins, you are going to need the Lawnard app. We built it for you, free on iOS and Android. I'm going to answer a few questions as quickly as I can, and then I am going to go to our meeting because we are finalizing everything to be in trial for like 4+ weeks. All right? Which is a lot. Casey Cat said no spoilers, but oh my God, Proctor. I mean, the Proctor of it all. To everyone who gifted memberships today, thank you. For all the new members, we are going to be doing an After Dark members only as soon as we can. I'm not sure exactly when, but we are doing an After Dark members only. Our After Dark members only is going to include other Olympic controversy dealing with, penises. It's Emily, penises. We are going to have a whole penis problems After Dark. We still have the 50 Cent penis lawsuit. We have an influencer penis lawsuit. We have like 5 different penis lawsuits. And then we have an Olympic scandal also relating to penises. So we're just going to do an entire After Dark episode of the members only. Trisha Lynn, in addition to the running out of condoms. No, this is a plus. In addition to running out of condoms, which seems to always happen at the Olympic Village. And that's a conversation for members only. Firecracker said, I'm coming back from France and spent all week with chocolate croissants and double espressos. Delightful and delicious. The Big Kapowski said, I'm wearing my blackout I have questions hoodie. It's literally the perfect hoodie. These drop shoulder hoodies, I love our zip ups. The zip ups are thicker. They are perfect, but they are great if you are chilly. The drop shoulder hoodies, like the Lawnard hoodie, is a lighter weight hoodie that is perfect for like all the times of things. All the times of things. Cat Mom, we are working on V-neck tees. I cut a lot of our tees, but we are working on V-neck tees. I have not found one that I like. The cuts that we have found are all cut really narrow in the torso, which does not work. My body is not cut like this. A lot of us are not cut like this. And so I have not found a V-neck that we like. So when we find one, we will. Loki in the chat, or Lochi in the chat, said, I find law and crime unnecessarily sensational. I agree. It is, yes, I agree. I agree. It's frustrating. Quoting CJ, aw shit, here we go again. I mean, ready to just go. Aaron in the chat said, in Texas, prosecutors can face serious consequences for not turning over evidence, even in acquittal, even decades later. Is that true in other jurisdictions? It can be. It can be. Even in acquittal, there can be consequences for not turning over exculpatory information. Yes, there can be. I don't know if we will see that here, because I don't have a lot of faith, honestly. I don't have a lot of faith. It's frustrating. Casey Cat said, I know Karen Reed was acquitted, but with all of the new disgusting stuff coming out from Proctor's phone never provided, the Karen Reed team shouldn't Lally Morrissey be sanctioned / disbarred. They didn't have the personal phone either. So when it comes to Proctor's personal phone, this is all stuff that was discovered after the Karen Reed stuff was done and that the court ordered it. It is not the practice or policy to turn over work phones. It is almost never that you're going to get into a personal phone. So once it came to the DA's attention and they had the personal phone, then they needed to turn it over. They didn't have that before, and it was never ordered before. So I think there are some with Proctor's personal phone, because that was after, I don't think that's as much of a problem. If stuff comes out that the prosecution had or should have had during the time of trial, that can be a problem. That can be a problem. Firecracker, do you know the FBI agent who investigated the cases running for Norfolk DA? We talked about that a while back when Morrissey was giving a statement, or when Morrissey announced that he wasn't running. I'm sure that they have interesting things to say about it. Virginia, thank you for the gifted memberships. We will take a look. I think we needed code 404. I think it's going to get added. Yeah. Code Puce would be funny, but I wouldn't look cute on film. So I have to keep in mind that I am also having to look at myself on screen. Jenny and Stitches, I have every phone I've owned since 2001, right? This makes sense. Schematics or schemic, my brain is not parsing the words right. Economics 5992. Emily, you need to switch to the Richter scale. This is definitely an 8.8 on the Richter scale. I might have too much Los Angeles PTSD for a Richter scale, but I do think code 404 works. Casey Cat said Proctor has now become a verb. 10 out of 10. Boyo 2012 said code 404. I am enjoying this we're in timeout vibe with the fuckery going on. I did. I put myself in timeout because I think we did need code 404. I'm going to have to find a black light. Jay Briley, I have not picked my DMB summer schedule yet. It has been on my list for like a million different days to sit down with Travis's tour schedule and the DMB tour schedule. And I haven't been able to do it yet. It's literally on my agenda for this evening, but like stuff keeps happening in other cases. And then last night, like YouTube just went like bloop. YouTube just went like bloop. And so there was, so it just keeps not happening. I'm not sure where I will be, but we are working on doing some Lawnard live events. We have had conversations this week about it, so we are working things. Thank you, Cephal. Thank you so much for the 50 gifted memberships. Welcome to all the new members. I will make sure that we are doing a members only with the After Dark within the next 30 days so that all of you that were just gifted memberships can participate in that. Martha, I'm definitely not mad at the Canadians. Look, I could never be mad at the home of all dressed chips. I think the boop the snoot, I am amused. Also, curling is not my thing. I was just flabbergasted because curling is such a it just seems like such a congenial sport where everybody kind of sorts things out themselves. And then to have the bloop, it's just wild to me. But no, not mad at Canadians. I mean, others might be mad at Canadians. I'm not. I'm sure everyone is frustrated, but I am amused. I'm amused. A number of you are saying that your orders have already shipped from the Lawnard shop. I know, right? We have worked so hard. Anna Strong said that meme is what Seligson and AJ were texting. Oh, 100%. 100%. A number of you are saying that your Lawnard order already shipped. Absolutely amazing. I love it. Let's see. Personal predilections is beautifully grotesque. I mean, they definitely painted a picture with their words, didn't they? They definitely did. Love all of my oversized hoodies and added 2 more with this launch. Thank you for finding comfy clothing items. You guys, I love hearing the feedback. I love that you love it. When we explain, no, I need to touch everything and I need time with it before we decide that it is something that we are going to put out to the law nerds. It is something that we work on quite a lot, and we work on very mindfully to make sure that we are bringing you A, things that are quality that you love, B, things that aren't just going to fall apart, and C, things that I have personally touched, tried, washed a million times, and wear and love. And it is very much something that I work with and the team works with quite a lot. So it is on our mind constantly. So to all the new members, welcome. Get ready for trial. Y'all are going to love no slow mode in the chat when we get into trial. Get ready for trial because we're going to be getting into trial next week. I am working on something for tomorrow, so we might have a change. In schedule. Stay tuned in the Lawnard app. I will let you know. There is stuff going on in the Richens case. If we are able to bring that to you, then there might be a change in time. If not, we will be covering other stuff. So it just depends. And then Monday, back in trial, everybody. So make sure you have the Lawnard app. I appreciate you. It's good to see you. Lawnards, cheers for a XL style live stream. But I hope getting through that whole group of material at once was helpful. It's been a minute since we've jumped back into Karen Reed. I hope that grouping it together gave kind of a understandable flow of the issues that are going on all over the place. And there is so much more happening. But as we are getting into trial, it is a balance of what is more timely and urgent and what isn't. So I will see you all tomorrow. I will let you know what time. And then y'all, we're in trial. So once we're in trial, we're in trial. And then everything that we have not gotten to will happen after trial. Trying to onesie twosie stuff while I'm in trial breaks my brain. Once we're in trial, I'm all in. I'm just like, it's hard for me to focus on anything else because I have been so ready for the Corey Richens trial to start for so long. My focus is definitely being pulled in that direction. I want the trial to start. I am ready for trial to start. I am ready. We have been waiting. It feels like for a million years for this trial to start. I am ready. Ready for trial. I will see you guys tomorrow. Take care of yourselves. Take care of each other, law nerds. Remember, I will keep you posted in the app. It's okay to turn off everything else. Enjoy the Olympics. The pull of breaking news right now is crushing. You do not have to be crushed by it. It's okay to opt out for a minute. You guys will be good. If anything critical happens, I'll tell you in the app. I've got you. I will see you soon. Law nerds, have a good night. Trial. I'm ready. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Lawnard.